Madam, may I be happy to mention item number 38 of your lordship's list. This I am mentioning on the leave granted by your lordship on the last occasion. That I made a prayer before your lordship. This matter is a very urgent matter. We are deprived of our pension for a long time. Madam, may I be and we suffered an order by the trial court. We prefer to appeal against this order. Item number 30. I made a prayer before your lordship. This matter, your lordship was were pleased to fix the matter on the last occasion, but it could not reach as such.
So what is it? Then it will go the after 15th of February.
15th of
February.
As you lordship, this matter, 15th of February.
Your other side, Mr.
It could not reach as such.
So what is it? After 15th of February.
15th of
February.
As you lordship.
Your other side. After 15th of February. Mr. Bhattacharya, if it remains here, it will be advantageous for you. Otherwise,
No. As you lordship. 15th February.
No, 15th February, it won't be possible. My brother won't be there. He has to raise a circuit. So here is difficult to fix up a date. Let it remain in the list. If we reach. Otherwise, we will fix it after my brother returns. No, 15th February won't be possible. Yes, my
Group 6 hearing, appeal. That's an old matter. Group 6,
Which year?
2017.
Let it remain. Are you mentioning upon notice? Please do not mention without notice. Give a notice and tell us.
I served notice the tribunal of
Here we follow. Give a notice and come back.
paper.
It has been hard, my lord. My lord, 9/12 last month, my lord, is the issue of removal from service where the disciplinary proceedings.
Is it in the list?
It is released in the monthly list on that date, my lord. Honorably told, he mentioned when the monthly list published, let it be a supplementary list any date. Removal from service, my lord, covered by my lord's judgment. I already noticed to Mr. Jena, also Kumar Jena. Any date for supplementary list.
What is the item number
48, my lord.
of the combined list? So it will be reached.
I'm sure I waited, my lord. This is a removal from service in 2017, my lord. I am suffering lot, my lord. 2025, my lord. 7 years already been passed. This is covered by my lord judgment, my lord. I am acquitted in the criminal case. Same set of facts.
Yes, the other.
My lord, may I be permitted to mention, my lord, two applications, my lord. One for, my lord, restoration of the appeal and another is for, my lord, the withdrawal of the appeal, my lord.
Withdrawal of appeal.
My lord, for non-prosecution. My lord, what has really happened, my lord, is
Two
that
matters.
two applications, my lord, in a connected appeal.
Two
Two applications in an appeal. My lord, one for, my lord, restoration of the appeal and, my lord, another is for, my lord, the withdrawal of the appeal. My lord, what has really happened, my lord, is that, my lord, by an order dated, my lord, 1st of March.
Let it remain dismissed. What then?
No, my lord, what is, my lord, the matter is, my lord, by an order dated 1st of March.
We don't want to hear you are wanting to restore and thereafter
to withdraw, my lord. My lord, because, my lord, we have, my lord, the department, my lord, the state response. I'm the appellant, my lord, petitioner appellant, my lord. This, my lord, may I, my lord, the facts may be needed, my lord. My lord, my PATA was cancelled by an order dated 1st of March 1994. We preferred a writ petition. My lord, the state respondent, my lord, came, my lord, and my lord submitted that, my lord, the order, my lord, cancelling the PATA, my lord, was not communicated to me, my lord. Thereafter, we preferred another writ petition, my lord. There, my lord, the state respondent, my lord, submitted an affidavit, my lord, with the, my lord, office memorandum stating that the order has not been passed, my lord.
We don't want to enter into the fact at this moment, but we want to know only a clarification from you. Why you want to get it restored?
My lord, just to, my lord, bring on record, my lord, that, my lord, affidavit of the, my lord, the state respondent, my lord, bringing on record this affidavit of the state respondent, my lord, the appeal will be dismissed as infructuous, my lord.
My lord, may I be permitted to
We
mention?
mentioned it the
Lord, may I be permitted to mention a new listing of a new appeal, my lord?
new appeal hearing.
My lord, it is yet to be admitted, my lord. It has not been anywhere been listed and heard, my lord. Not once. We have
Which
served,
year? Which year, Mr. Dutt?
my lord, it is of 2020, but my lord, the urgency is they have filed a contempt and rule has been issued. So this is the difficulty, my lord.
Sir, may I have Lord's leave? So last Friday, Lordship, we mentioned on matters where the threat of contempt, my lord, in the state appeal, my lord. Lordship was pleased to direct the other side to send a notice, Lordship. I have Lordship.
Yes.
For a new application.
Contempt.
Lordship is not a contempt on the appeal from the state appeal, my lord.
Lord, new application in
Yes.
Lord, new application in connection with appeal.
Yes.
Your Lordship, kindly urgency is there.
I have served this to the other side. It will be added as a hearing. Group 1.
Group 1 of which year, sir?
2023.
20?
23.
Give this.
May I have my lord, I leave to mention one
Wait,
matter.
sir. Wait, sir. Yes.
My lord, petitioner is aged,
Next file ele debe.
my lord, petitioner is aged about 83 years.
Matter.
My lord, WP
Is it in the list?
In the list or outside?
No, out of list.
Acha.
My
Give
lord,
the slip. Give this.
Sir, one application, my lord, for new
Yes.
application for stay, my lord, and matter.
my lord, this is an application for restoration, my lord.
May I permit to
Where
mention,
is
my
your
lord?
notice, sir?
My lord, notice I shall start, my lord.
No, please give a notice and mention. That is the procedure we follow. Give a notice, mention on
State is the other side, my lord. State.
Very good. Give a notice and tell us on Thursday.
May I permit to mention, my lord, the matter in regards to the service, my lord.
What do you want? Appeal hearing.
No, motion is there. I am filing for a expeditious disposal, the appeal petition, and that petition
Application.
till today, application pending till today. So I am respondent in this case. The respondent was the candidate of
Whose appeal? It's state's appeal.
yes, my lord.
So was it heard at any time?
No, my lord. The
When
matter,
was it filed?
the appeal in, my lord.
Huh?
Oh, when? 2014.
So what were you doing for these 8 years?
My lord, this is change brief, my lord. Prior advocate did not take any
So
action.
the state will mention it is not your appeal. Have you
No,
filed any
No, I am
application?
respondent.
Maybe. Have you filed any application in connection with the appeal?
Yes, my lord, for expeditious disposal.
So are you mentioning upon notice?
No, my lord, after change brief, so I did
So
not.
give a notice and mention on Thursday.
Kindly inclusion in the list. Thereafter, I am.
No. Give a notice, then come and mention on Thursday. Yes. Or
May I be
Monday.
permitted to mention a matter for inclusion in the list,
Uh-huh.
Lordship? For inclusion in the list, Lordship.
Hearing matter
Lordship, it is a fresh contempt application, Lordship. They have
of this bench.
of this bench. The other side.
One contempt application filed by us and another review application filed the state authority, my lord.
Fresh contempt. Fresh contempt.
Fresh contempt, my lord.
Review of our order.
Yes, my lord. That has been filed by the state authority.
When was it filed?
It was in the year 2024, my lord. The matter was taken in the month of September, 20th September. At that time, your lordship was pleased to keep this matter 3 weeks after vacation, my lord.
Yes. Call the list.
Lord, I am Lord, I appear for the status. Petitioner before your Lordship is the land.
Yeah, just one. What application did you file? Contempt application.
Contempt.
And you did not annex the order.
Yes, I have annexed.
You already.
That is, your lordship kindly extend the time.
Is for accommodation to
Quota, that is not,
undertaking to furnish a copy of the order stated to have not been complied with.
that was annexed. In that petition. That is not correct.
Then why didn't you tell the court that is not correct? You Nilofar Begum appeared.
Learned advocate gave the.
Huh.
It is a very unfortunate, I do not know.
But
This is the annexure is already there in the contempt application.
So sir, you were there. Tribunal,
Sir,
you were there.
Kindly shorter the time, order was passed in the trial court.
Where is that order? Which ordered contempt you are saying? Have you annexed?
Yes, yes.
Show us.
Page.
কি বলেছো?
That is
59.
page 50 and 49 and 50. Page 50.
কি বলে? 50.
50.
50 you are alleging violation?
Yes.
59.
59.
Oh, 50.
50, my lord. 59 is the earlier one. That
That
is
is an inherent defect which cannot be rectified. Permission to
no, this is the second. First order is
just to make a rendition.
No,
This is
you short for
withdrawal.
withdrawal.
and also his lordship had directed to file an application that will be considered.
Where?
But this is the learned advocate for the applicant submits that.
Which page, Mr.
Page
Adef?
50.
Page 50.
Yes, P6.
Learned advocate submits there is an inherent defect and he wants to withdraw.
Yes.
So withdrawn.
Withdrawn. And thereafter, his lordship directed to file an application that will be considered in accordance with that.
Which where?
No. Oh, yeah, appointment.
Where is that line, sir?
That was withdraw.
The first paragraph itself, when it says she submits for granting permission to the applicant to withdraw this OA and to file proper representation before the BLRO, strictly in terms of the order passed by this tribunal, in OA number this, with prayer for expeditious disposal.
That is
My lord,
that is
now, my
the
lord, if your lordship kindly sees the penultimate paragraph, having this third paragraph, having considered submission of both, the applicant is permitted to withdraw her OA and liberty as prayed for is granted exclusively at the risk of the applicant if so advised.
Yes.
Mrs. Begum, learned advocate, is requested to make her endorsement on the first page of OA regarding voluntarily of this. No such direction was given.
So
But they are relying upon the order passed in 1682 of 2010.
Yes.
That was the submission made. And that is, my lord was referring to page 59.
Yes. Page 50.
59.
59.
Page 59.
Yes.
But only liberty was granted. No such direction was given.
Now 59 is the order passed in the same application.
The earlier application.
Earlier
Application. This is a 2010 application. Page 59. And page 50 is an application of 2020. The second last paragraph. Page 59.
This is an earlier LRT.
LRT.
In that was what was this application MA?
MA that was dismissed for default. Thereafter, MA was restored.
All right. Now this 2011, 2010 LRT was disposed of with a direction upon BLRO to treat the application as a representation of 6 months.
Within 6 months.
Then what happened?
No, nothing was done till then.
No.
Then why did you file the fresh writ of 2020?
Another representation again filed. Therefore, that was challenged. At that time hearing, this was also referred. This was also referred. Then his lordship.
What do you want?
Where is the specific order, violation of which is complaint of?
Within 6 months, consider that will be the.
So that
That is not the subject matter of this contempt application.
But till date, nothing was considered.
This contempt
Mr.
application.
Arifin, 2010 order, 10 application you disposed of directing BLRO to consider.
Yes.
They did not consider.
Yes.
So you filed a fresh OA.
After 10 years.
Fresh representation again.
No, fresh OA, page 50.
And thereafter fresh OA.
representation যা হচ্ছে এবার
Thereafter
50
fresh.
fresh হয়ে
Yes.
fresh হয়ে dismissed as withdrawn.
Withdrawn and also directed Miller to
PLR.
in that
Permission to withdraw was granted and liberty was granted.
granted.
Where the contempt lies?
Well, in accordance with the way number 1682. Therefore, Miller,
You withdraw with liberty to file application for preponement. At the best we can do so.
What survives in the original application? Mr. Siddiqui, why it has been kept returnable as application?
But that, my lord, I could not make because returnable after 26th August 2025, my lord.
No, for what? Because he was withdrawing the original application.
But your lordship is referring.
এটা তো আবার MA করেছে MA করেছে করে বলছে এই 50 অগস্টটা ভায়োলেট করেছে
এমএটা তো ইনে withdrawn petition কি করে হবে?
হ্যাঁ সেইটা
This is dismissed as withdrawn.
ডিসমিস উইথড্রন
He praised.
স্টপ অ্যাট
কোথায় লিখুন? হ্যাঁ।
হুম
No, this is 1107 of 2020.
20. Against this order 1107 of 2020, the fresh contempt application has been filed, which is there before your lordship, the last page.
Nothing is required to be passed in this. No order is required to be passed in this.
I am very
You withdraw with, we will give you liberty to pray for preponement of the matter before the trial.
actually, my lord, one after another we have
This is not the procedure, Mr. Arifi.
civil court has already been declared permanent injunction. In spite of
cannot
that,
do
they
that.
will not correct it.
Sir, we
In
cannot
view of
enter
the
into-
judgment that degree passed by the civil court.
we cannot enter into the mail. You filed a contempt application alleging violation of the order dated 7th April 2022.
My lord. My lord, I
So
understand.
if you want to merit regarding the contempt application, we find that no specific order has been passed. Only a liberty was
My lord,
granted.
actually, specific order was passed in
And
1682 of
now,
10.
however, what is that contempt application, a tribunal decide on merit? Here you have come for expeditious hearing. Date has been fixed on 28th August 2025.
Yes.
We here, sitting here, cannot prepone the date. So take liberty, file an application for preponement. Tribunal will prepone the date.
Yes, Neil.
Right.
Acha, on the pair of Mr. Arifin,
Your Lordship, I'm appearing for the appellant. Your Lordship, on the last date, your Lordship had granted a stay of the order dated 25th, dated 3rd May 2023. And we were directed to serve the same upon the private respondents since they have not been appearing. We have served the order on them, but the service is not yet complete. Praying before your Lordship kindly keeps it any day after Wednesday so we can derive the report from the GPO. It says that item has been returned to us, but we've not received the item as of yet.
একটু combined monthly list আছে ডিরেকশন ছিল ওখানে চলে যেতে পারে এই তো লাস্ট that it was directed to list in a January monthly list, no?
Yes, my lord.
Then how it is coming in the supplementary list?
My lord, on the last day, it had appeared in the monthly list. On that day, the affidavit of service was not complete. So your lordship was pleased to direct the matter to appear in today's list.
Oh, so today what is the problem?
My
You
lord,
have
the
not completed service. Are you appearing?
Mr. Jayanta Samanta for the state.
my lord, they are appearing for the state, but the
Yes.
main writ petition, who is
Uh-huh.
the main opposite party
Uh-huh.
for hearing this appeal, my lord, it is stated that item delivered. As far as this is Naresh Kumar Agarwal is
Is it on
concerned.
the point whether interest will be paid
Yes,
or
my
not?
lord. Yes, my lord. But they have to be present because we are of the view.
Have you served upon him?
Yes, my lord.
No, pursuant to our earlier order dated 10th December, have you
Yes,
served?
this is the service pursuant to your lordship's order.
Then they are not appearing.
They are not appearing.
Oh,
Another opportunity, you produce the document showing such service. Affidavit of service have you filed?
Yes, my lord. This is
Prepared or
affidavit-
affirmed?
No, my lord, this is not affirmed because
Oh,
this is stating that item returned, but we have not returned.
done or delivered, whether delivered or not. You show to our officer?
My lord, this is not the affirmed copy because we are not getting the updated status. We will just obtain the updated status from the GPO today.
Item delivered. Next week. Interest payment is next month.
দুদিন actually বলছে। Then we simply adjourn it. What order is required to be passed?
My lord,
You have affidavit of service you have prepared.
yes, my lord, prepare, but this is not the affirmed copy because we are not
You
aware.
have not affirmed.
Yes, my lord. So we have written a letter to the GPO regarding the status because they are saying the portal shows the item returned and not received.
Uh,
2 weeks, sorry. I mean 2 weeks for you.
keep it after 2 weeks.
Keeping it after 3 weeks.
Well, if your lordship's wishes, we can make a paper advertisement so that the item has to be, this matter has to be heard because in the similar
Why
kind,
paper advertisement?
but that
You complete service, you ascertain within 2 weeks. If not given, you make a fresh service. Finished. Yes.
dreadful, man.
For 3 weeks.
2 weeks, my lord, 2 weeks.
Oh, 2 weeks.
ঠিক আছে।
Okay, dismiss as withdrawn. Dismiss as withdrawn.
Yes, next.
That we are appearing for the state respondents, my lord.
My lord, item number 4, my lord, I beg to appear for the appellant. My lord, I seek for my lord's pardon at the very beginning, my lord. I am being led by Mr. Kollol Basu. A matter, my lord, which is part heard, is going on in court number before the division bench of his lordship, the Honorable Justice Horish Tandon. My lord, today, if my lord excuses us and my lord adjourns the matter for the day, I pray.
How many days delay?
My lord, delay.
105 days.
105 days delay.
105.
105.
105 days.
Any private respondent? Is there?
No,
My lord, no.
You're appearing for all.
no, my lord. Only for state.
Have you completed service?
Lord, service has been completed. My lord, the affidavit of service, my lord, it is with the advocate on record. Are you there?
Not this week. Yes.
Great. I'm grateful, man.
Well, my appeal, well, there was a direction to file affidavits in the condonation dilemma. Well, now I'm receiving the opposition.
Which items?
5 next.
What happened?
There was a direction for affidavit with regard in connection with the application
Condonation
for
of
condonation of delay.
Now, my lord, I'm receiving the condonation opposition.
Delay of how many days? How many days delay of?
They
No,
say it is 170 days. We say it's more than 212 days. Because since the certified copy is not with me, I cannot say the exact date. But it comes to, they say it's 190 days. We say more than 212 days according to my calculation.
You are for the petitioner.
Appellant.
State risk.
Appellant.
Appellant. No, state is the appellant.
Appellant here. And for the petitioner's response.
Restoration. Restoration in.
No, regularization.
Huh?
Issue of regularization.
No, the appeal was dismissed.
No.
এটা তো 6 নম্বরের ফাইলটা দিয়েছে। এটা কেশোরাম।
It is Baljinder
State
Singh.
versus Baljinder Singh.
ওই দেখো ইন পার্সন হিস্ট্রি রোশন করে এই যে কোনো রকমের লিখলাম ওই ডান দিকে লম্বা করে লোকটা এই যে লিখছে for regularization.
Yes, ma'am.
So why you have come up in appeal?
The state has come up in appeal.
Why?
My lord, the principal issue, my lord, would find in the order, which is at page. My appeal has been preferred against that order also. My 168, my lord would find there's a reference. My lord, kindly come to page 168. My lord, the order impugned before my lord. But
Yes, impugned
Yes, my
order
lord.
is 2nd February.
2nd February, yes, ma'am.
Yes.
My lord, the last paragraph, the
Yes.
penultimate line, my lord, there's a reference to a writ petition.
Last paragraph
Yes,
of
ma'am. The last 3 lines, 4 lines. A coordinate bench by dint of the order dated so and so.
where you are reading
My lord, 2nd February, the last paragraph, last 4 lines.
internal page 2.
No, first page, my lord.
Yes, Dotto appearing for another writ petition.
That was also challenged, that is pending before lordships. In connection with that matter, was a contempt. We had state had preferred an appeal against the contempt order of contempt. That is the contempt is state. So all these appeals, according to me, has to be heard together. This we have.
Mr. Chatterjee, learned advocate appearing for the writ petitioner stroke respondents, files the
Item number 6, my
Please, your lordship.
Lordship, Mr. Galib is appearing in this my lordship matter. Not well.
Led by Mr. Shubhashish.
Mr. Galib is appearing in this matter, my lordship. He is not well today, my lordship. I'm praying for not today, my lordship.
not this week.
I am for the appellant. They have filed in report, your lordship. We have filed on our exception to the
Yes,
report.
my lordship.
May
May
I
we
file
receive
it?
the exception on Thursday or Friday, something like that, my
You have
lordship.
served, your lordship, within time, whatever your lordships pass the order. The last order, as per the last order, your lordship, we have served them the copy within time. There's an extension of time to file an exception.
You have filed the exception.
No, your lordship, I'm carrying the exception. We have served the copy to the other side.
Oh, Mr. Dotto, learned advocate appearing for the appellant, files the exception to the
Event for the respondents, my lord.
সুমনদা ছিল, সুমন সেনগুপ্ত ছিল তো আগে।
হ্যাঁ, শীত ছিল। বলুন, ফরওয়ার্ড আছে যখন।
জাস্টিস দেবাশিস কুমার গুপ্ত বই আনেনি।
মেসেজটা নিয়ে আসছে।
Yes, what?
My lord has heard this matter, my lord, earlier, my lord. It is that matter, my lord, where I have challenged the order of the learned single judge, my lord, on the ground of jurisdiction.
Oh, acha, acha.
On the
সুমনদা আপনি স্টেটের হয়ে
না,
ওই
You are appearing for whom?
Writ petitioner respondent.
Private respondent here, writ petitioner.
Yes, tell us what happened, Mr. Bhattacharya. Just remind us.
Yes. Kindly see, my lord, the impugned judgment, my lord. Kindly see, my lord, the order judgment dated 15 July 2024. Now, my lord, the honorable, this writ petition, my lord, initially, my lord, this Ranjit Mondal, my lord, he had filed, my lord, an original application before the Block Land and Land Reforms Officer, my lord, for correction of the record of rights. My lord, initially that was, my lord, rejected. Now, my lord, an appeal was preferred. Appeal court, my lord, appellate forum had remanded the matter to the BLRO, Block Land and Land Reforms Officer, my lord, for a fresh adjudication. My lord, after that, the Block Land and Land Reforms Officer was sitting tight. Now, my lord, challenging that in action, the writ petitioner had filed a writ petition in the Group 1 determination of this honorable court for expeditious hearing of the proceedings before Block Land and Land Reforms Officer. Now, my lord, I have twofold points.
I see. Yes.
In the
No,
group,
when the first representation made, it was considered by the
they
BLR.
considered, then my lord, appeal.
The appellant, Ranojit. Ranojit
Writ
preferred.
petitioner, yes.
Achha, Ranojit made an application to BLR.
Yes.
And that was, an order was passed.
Yes.
Against that, Ranojit preferred appeal. Appellate
Remanded.
authority send it to remand. BLR. Then what happened?
With a direction to dispose of the miss case. Now, my lord, after that, the Block Land and Land the block after remand, the Block Land and Land Reforms Officer was sitting tight. They did not challenging that inaction. My lord, at the present writ petition has been filed. My lord, for my lord, to conclude the proceedings before the Block Land and Land Reforms Officer. My lord, and first point is, I was never, my lord, made a party in the writ petition. Also, although I was a necessary party. What happened after service of the writ petition? The revenue inspector, my lord, came for a, my lord, inspection in the suit property. From there, my lord, we came to know that this present writ petition has been filed.
Revenue inspector came for
BLR.
inspection. Got it?
I do not know, my lord.
What is?
RI.
Inspection.
RI. Then he reports to the Block Land and Land Reforms.
Inspection.
My lord, from there, my lord, we came to know that present writ petition has been filed. Now, my lord, on the day when the writ petition was disposed of, it's not that we did not appear. We appeared. But we prayed for, my lord, since it was, my lord, on the very next day, we could not file any formal application. But my submissions, the learned trial judge has been very kind enough to note my submissions in the impugned order. Kindly see the order dated 15 July 2024, my lord.
So when the BLR was sitting tight, he came to the writ court.
In Group 1.
In Group 1, also. He should have approached the tribunal.
That is in action. Lord, I have brought, my lord, L. Chandra Kumar, court of first instance. Number 2, my lord, this is, my lord.
You have filed a leave to appeal.
Leave to appeal, yes. Yes. That is, my lord. Can 1.
So you were heard by the writ court.
Yes, but not formally added.
So what was the reasoning of the single judge?
My lord, kindly comes to.
What is this 30th November 2022?
Lord,
First page of the order.
That is remand, order of remand. Kindly come, I'll show to your lordship. Kindly comes to page.
Achha, then
31. Page 31.
Page 31 of the stay application.
Stay application. That is the annexure to the writ petition.
What you are showing, this is the order of the appellate authority.
Yes. That is, my lord, 30th November 2020.
In that appellate authority, you were heard.
No. No notice was served.
Both the appellant and respondent submit?
No notice was served. I was taken specific instruction. My client came to know from this writ petition only.
No, you came to know from the inspection.
That is the writ petition. That is the writ petition.
No, the revenue
RI.
inspector went to the
After filing and service of the present writ petition.
service. You are not served because you are not
I
a
was
part.
never served. I am not even a party to the writ petition.
That is why. So you came to learn when the revenue
RI.
inspector went to the spot. And then how did you come to learn about this writ petition?
He told me that present writ petition has been filed.
The revenue inspector.
The revenue inspector.
Where have you stated that in your leave to appeal application?
Lord, application. Yes. Kindly comes to Millard para the 5 onwards at page 4.
Hmm?
Can 1 page 4 para 5 onwards.
What is your name? Ranjit and Motilal.
My lord.
Ranjit and Motilal, your name.
Yes.
You are presently the recorded persons
I am the recorded person.
of the concerned land. Para 5, what did you say? After disposed of the appeal, then one of the officials came to. Acha. Now, very good. Now, what did the? Oh, you were heard before the
Yes.
court.
I appeared before the
Maintainability point was raised by. Then what happened? What did the court say?
My point was overruled. This is substantial justice. Court is only directing expeditious hearing without going into the merit. That is the reasoning. Kindly see the page 2 of the impugned order. I was definitely heard.
November 30th was the order of the appellate. There it says that you were heard.
Yes, but we have never received any notice.
Challenge. যখন করছে মিট করা অ্যান্সার আইনে ওকে নিরস্ত করার মতো কোনো যুক্তি নেই সকলের যুক্তি ওর
মানে ইলেকশনটা বিরুদ্ধে ওখানে নাকি এখানে রিপোর্ট হচ্ছে সাবস্টান্স জাস্টিস
ফোরাম তো কিছু করার নেই ও যে জায়গা ধরেছে করার
And Millard kindly comes to page 15 of the stay application.
Where is your memo, Mr. Bhattacharya?
Memo is here, Millard. These are the page 15, Millard. I was
page 15
one
can
of the stay petition. Yes, can two.
So your name is
Pratima.
Your name is Pratima.
Yes.
No, the petition was filed by Ranjit and
Motilal.
The land was recorded in whose name?
Our predecessor.
Namely Manik.
No, Millard. Probodh, Millard.
Probodh.
Manik and Probodh.
And they want
their name to be recorded
their name
or because they are in possession. And there are, my lord, civil proceedings also pending. Ex parte decree, we have filed Order 9, Rule 13. Kindly see, my lord, that's what, my lord, I was showing to your lordship, page 15, my lord. My lord, kindly see the grounds in the writ petition. Kindly see 2. For the respondent number 2 ought to have considered the order passed by the subdivisional officer and land revenue officer Shodor Alipur South 24 where specific direction was given to the learned block and land revenue officer Bishnupur Bhasha 1 district 24 Paganas to pass reasoned order after giving opportunity of hearing to both sides. One inaction number 1, kindly see the next inaction. For that, respondent number 2 without any application of mind failed to consider the order of the learned subdivisional and land revenue officer Shodor 24 Pargana South, and in spite of repeated representation made by the petitioner in this regard, he did not comply with the order passed by subdivisional land and land reforms officer Alipur Shodor 24. This is complete, my lord, inaction. And my lord, ultimately kindly see the prayer made in the writ petition at page 16. A writ in the nature of mandamus directing the respondent number 1 to comply with the order of the learned the respondent number 2 in LRA case number such and such arising out of the order passed by the learned block land and land revenue officer Bhasha 1 district 24 Pargana South. Complete inaction which is barred under Milord the West Bengal Tenancy Tribunal Act. কোনটা ছিল গো প্রভিশন গুলো 6
এটা রুলস করেছেন আপনি
6
একটা 6 8
Section
6 and 8
jurisdiction
এখানে আছে নাকি একটা yes
kindly see 6b kindly see 6b
inaction এই যে
এটা 15টা আছে before a division bench it has to be before. Where is that provision that against the order passed by the tribunal it has to be before a division?
Yes, that is Milord 8 Milord. On and from the date from which the jurisdiction, power and authority becomes exercisable under this act by the tribunal, the High Court, except where the court exercises its jurisdiction under Article 226 and 227 of the Constitution by a division bench, or any civil court except the Supreme Court shall not entertain any proceeding or application or exercise any jurisdiction, power or authority in relation to adjudication or trial of disputes or applications relating to land reforms or any matter connected.
Yes, what do you have?
Yes, I leave it to your lordship. There is a question for jurisdiction, my lord. Very frankly, I leave it to your lordship.
I have brought Milord L. Chandra Kumar, and on similar point, a division bench judgment of this court. Here, Milord, at page 15, para 15, Milord L. Chandra Kumar has been quoted. And ultimately, Milord, para 16 is the ratio. 16, 17, 18. Inherent lack of jurisdiction. And the second one, Milord, my second point is, Milord, another one is which one? Milord, this is Milord Milord, this is not the lack of Milord pecuniary or territorial jurisdiction. This is inherent lack of jurisdiction by the statute. Milord, this is Milord 51 Supreme Court parent judgment. 61 Supreme Court. Page, para 4. Objection to its territorial jurisdiction which goes on not in competence with the court cannot therefore be waived. In the instant case, lacking it is laid down by the Privy Council that the court in which the suit has been originally instructed was entirely lacking jurisdiction in the sense that.
But Mr. Bhattacharya, when the court for the ends of justice does anything, do you have any authority that in such exercise of discretion for ends of justice, read court?
Not in group 1, Miller.
It says to serve the ends of justice. No useful purpose will be served. I am disclosing.
No.
There is no judgment pat on the issue.
No, not at all.
That I cannot exercise my discretion for the ends of justice.
That is not. But this is a
But
legal.
had there been a prejudice against you, then you could have said that, see, this order has been passed which is prejudicial to me. As such, they have to go to the trial. But till date, no prejudicial order has been passed against
I kindly appreciate, Millard, to reduce the burden of the High Court, Millard, the legislature thought it fit to create, Millard, land tribunal, state administrative tribunal, central tribunal.
No, Mr. Bhattacharya, just we are interacting. Suppose today I think that the person is being troubled, he will also be suffering pendency. So for the ends of justice, you go and sort it out.
And court passes an order which is otherwise not nullity and not executable. Inherent lack of jurisdiction.
Wordটা use করেছে to subserve the ends of justice.
Had Millard a application under section 47 of CPC would have been filed. May I take your lordship's leave? May I take your lordship?
My lordship, I am from the compelling circumstances, my lord, I am mentioning this matter. My lord, your lordship kindly accommodate us for at least, my lord, 2 weeks, because Mr. Harajan Banerjee is appearing. He filed, my lord, he filed.
Why didn't you say so at the time of mentioning?
This is the
We
fourth day,
requested you that you ascertain.
fifth day. They are taking
My
this
lord,
time.
he is admitted in the Apollo Hospital, my lord. He is suffering from pneumonia. Lord,
And in the lower court, execution is not proceeding.
we are not
Totally stalled.
now, my lord, what happened, my lord, on the last Thursday he came. Thereafter, my lord, he was admitted. Now, my lord, your lordship,
On purpose of occasion, which was mentioned, and he will again mention after a few days.
no,
It
my
is
lord,
going on since-
matter is appearing before your
since
lordship.
since last several months.
My lord,
You are taking time on the account of Mr. Banerjee.
my lord,
Sir,
this is the compelling.
on the basis of the mention, we are including in the list.
whole problem.
And when the matter is being taken up, you are taking
My
time.
lord, only one thing, my lord, now the matter is appearing, your lordship kindly accommodate for the.
No, we cannot, because my brother won't be there. He will be in the circuit bench. We again cannot hear the matter.
My lord, my lord,
What we are to do, tell us.
my lord,
It is being
yes, my
mentioned
lord.
with consent of
My-
you. That is why we
No, no,
kept
my
it.
lord, I admit, my lord, my understanding is
So
accommodated.
you tell what we are to
My
do.
lord.
We are sending it out of the list, then you get and mention.
But in lower court, what is happening in the lower court? This matter is totally stalled. Nothing is happening.
No stay order has been passed. One, most probably, so far our knowledge goes, he filed review application.
No,
No stay application.
No
So
stay
there
application.
is no order restraining the lower court to proceed.
Actually, what
Our lower court is not proceeding due to pendency of this review application.
My
You
lord,
may
your lordship kindly
file
take it
application.
here.
What you
here,
have
my lord.
filed,
This is the-
execution case.
the execution is their execution. In that execution, we interfered. And that execution is still going on, and each and every day they are taking a letter from the advocate of records and they are depositing it over there. And the third court in Howrah, subject.
Why didn't you say that their review may be filed?
We told it. Repeated time we told it, but the learned judge presiding over there, he is not doing anything.
My lord,
Anything.
only one thing, my lord. My lord, considering this.
You do it.
My lord,
You do it.
practically, my lord, I am not in this matter, my lord. Previously, I.
Then who is the advocate on record?
My lord, Pakrapo, his son-in-law.
So where is he? Ask his son to come and.
My lord, he's the only son-in-law, my lord, he has also there, my lord.
Liability of the father-in-law is to take it.
My lord, kindly.
You bring the son-in-law.
Compelling circumstance. My lord,
And your lordship, if you go through the this application, this such
If
a
they file
frivolous
an application, you tell this fact that there is no stay order. There is no stay order in
Then kindly pass an observation.
What observation? What observation we will?
What they are doing over here?
What observation we will say that there is no stay order?
No. They are taking time and time again and again.
Go and tell to the court, execution court.
Your Honor, we told it again and again.
ওদের execution.
Again and again.
ওরাই proceed করছে না যে আমার একটা review
And in that lower court also, their relatives, I am not taking the name, their younger brother is the representative over that court.
That's the last chance we put.
And respondent number 1 is in deathbed. Respondent number 2 is a very old person.
This matter was placed in the list on several occasions.
অর্ডার শিটটা কি আছে দেখো, কোন অর্ডার পাস হয়েছে? Who is the review applicant? They are the review applicant.
Yes.
Did it appear before us earlier?
No.
This is the first time it is.
No. This is the 4th, 5th time.
No, my lord, review application.
Fifth time application.
আপনার ফিফথ টাইম ডেট নিচ্ছেন, ফিফথ টাইম ডেট নিচ্ছেন আপনি বলে দাও। Adjournment has been sought for.
An adjournment has been sought for on behalf of the applicant.
Such prayer has been opposed by.
Such pair has been opposed by the respondent. Stopped.
As a last.
However, as a last chance. Leaves the matter. As a last chance, the matter stand adjourned for the date. Leaves the matter for final hearing on 26th February at 2 p.m.
26 হচ্ছে 2 p.m. আছে তো
26th February at 2 p.m.
2 p.m. My lord, yes.
And we are giving oral.
Yes, yes. My lord, I assure
on
you.
that date.
Yes, ma'am. My lord, I assure you, Lord.
We shall read.
Yes.
And we shall dispose.
Yes, ma'am.
Irrespective of the
Because,
fact
my lord, I admit, my lord.
No, you will again submit. We know. On that day also you.
No, my lord.
This is the fifth time you are doing. No. We are very sorry about his ailments. But in these cases where your other side is opposing so much, it is your duty to make some other alternative. Because we are being embarrassed. On 26th also, let everything go soon. But on 26th also, the situation may be so. Then what will you do?
Then, my lord, alternative arrangement, if it is in the meantime,
Yes, next
there is
matter.
any crisis, my lord, we will make it. Okay. Keep looking.
Item number 9.
Lordship, in this matter, I have, I'm seeking an extension. I've prepared the affidavit. Lordship, this is a review matter, and I find that the documents relied upon during the review were not before the tribunal. So these are all subsequent documents. Lordship, I have
Not
prepared,
that, but your
I have
lordship had
prepared
directed
an
affidavit.
affidavit. Yes, I have prepared, but it has not come back after waiting. Lordship, I'm just praying for a fortnight's time. It should be back by then.
You are appearing for whom, Mishal?
The railways.
Union of India.
Union of India.
There is a section 5.
No, section 5.
This is Mira Ora, no?
Yes, Mira.
There is a section 5.
Most probably seeking pension or family pension.
Yes.
Huh?
Yes.
Lordship,
Section 5. There is a stay application. There is an application along with the review.
Application. Take the third.
There is a can 1, na? Section 5.
78.
102 days delay.
ফাইল করতে দেরি করেছিল একটু দেখ can
one.
Because we have neither have we received the
Can 1 section 5.
Can 1.
Have you got a copy, Miss?
Transfer
and can 2.
কি ট্রান্সফার ব্রিজ ছিল
Can 2 is the appropriate order.
Application for review recall.
We review মেমোটার সাথে ফাইল।
Review memo.
delay of 102 days. Yes, আমার কাছে কপি নেই, তুমি দাও নি।
Neither do I have a copy.
Or section 5 have not served upon you.
I've only prepared for the main petition. There's no section 5.
Ground is ill health of the petitioner. Anyway,
We served a copy.
Just a copy.
Give a copy to her.
I'll give a copy, Milord, and let it come up after.
On the joint prayer of the parties, comma, the matter stands adjourned. Release the matter for further consideration. 4 weeks hence, the parties would be at liberty to exchange their affidavits in the meantime.
Gotcha.
Yes.
That's I'm great.
Madam, for the state led by Mr. Arvind Chaturvedi.
For the university, my lord, led by Mr. Nilotpal Chatterjee.
My last occasion.
And I'm filing my opposition to their section 5.
Before the lordships and give a direction for opposition and reply. This is the reply.
My lord, 71 of days of delay. My lord, no proper explanation given by them, my lord.
That explanation will I have visualized kindly, my lord, come to page 2 of my affidavit in reply, apartment 4.
My lord, no annexure has been placed to that effect. In fact, my lord, I will be relying to decisions of the Honorable Supreme Court, my lord, also regarding this delay also. My lord, more than 5 times of litigation.
Wait, sir. Wait.
My lord, my apologies.
Yes, what is the wrong in this order?
Not actually, this order, arrear salary was, I preferred writ petition during my lord, lifetime of the petitioner. Petitioner expired on my lord 12 March 2023. I preferred a writ petition in the year 2017, and order was passed by the Honorable Justice Somapti Chatterjee, against which the Joint Secretary passed a erroneous order, my lord. And that order was not challenged. And yes, my lord, I prefer writ petition and appeal, just sliding that order, my lord, Joint Secretary. I challenge your lordships in appeal, give a direction that why you didn't challenge that order. So that was the mistake on the part of me. And my lord, I challenge the order before the Honorable Justice Joy Sengupta after, my lord, passing the order of the Honorable Division Bench order. So that may be erroneous, my lord, because I didn't challenge this order as a review or before the apex court. And that is the reason for filing this review.
Yes, then what is the ground of review?
But one thing is this, your lordship.
What is the new document on the basis of which you want to argue?
Because, my lord,
what are the grounds of review? Review can be filed on 2 or 3 grounds. You know that. There has to be an error apparent.
Only one thing is this, my lord. During lifetime of the petition.
That has been considered and rejected. That submission of yours has been considered and rejected. Now tell us what is the wrong in that decision and what are the document you could not place before the court.
Because college authority should come forward, my lord. Because without
for what college?
I got the salary, and that has been visualized on the basis of Right to Information Act placed before your lordship. So just visualize the authenticity of these documents, my lord. The college authority should come forward and tell before your lordships.
College not required.
Because entire order was passed on the basis of the, my lord, report from RTI.
No ground. This is still the fit case to me.
No explanation.
Well, kindly allow this section 5 application and fix a date of hearing, Lord. I shall later on satisfy your lordships.
Later on, you shall make new grounds.
No, my lord. I shall try to submit because I am not in a hurry.
Because you have no ground. What will you study? কি রিপ্লাই ফাইল করেছে?
অপোজিশন দিয়েছে
Opposition and reply of the section 5.
You argue on merits. We will consider.
কোনো ইয়ে
যেহেতু ইয়েতে argument করবে।
The arrear salary of my lord.
Yes, argue what is your ground in the review?
My lord. But kindly see
Earlier there,
page 68, my lord. The reason order passed by the
reasoned order is not to be reappreciated. We have considered the reasoned order, we have rejected your appeal. And on what ground we should look into? What is the ground of review?
that is in disguise, that is hidden in the
If you have
reason
filed
order.
a matter, please get ready and make submission. When you are filing a matter, Mr. Ahmed, you should get ready with your brief.
But my lord, I know this is a very limited scope, but scope, one thing is, my lord, very sensitive point is this, my lord. Kindly have a look, my lord. In reason order that I have stated in appeal, my lord, review application. That, my lord.
Just a moment, let us go through.
Page 5.
Where is the order of the single judge against which the earlier appeal was preferred?
Yes, my lord.
8th March 2016.
Page 41.
Page 41.
Yes, my lord.
Against this she preferred appeal.
My lord.
Yes, my lord. Page 41. My lord, page 40.
Just a moment.
Page 41 is সেখানে বাইরে রিজেক্ট করছিল প্রথমে সাথে শুরু
But this is not a salary certificate.
Wait.
No.
Yes, Mr. Ram.
Yes, my lord. Kindly, my lord, see page for 2 of the impugned order, my lord. The petitioner, in order to substantiate the claim, has filed a supplementary affidavit annexing a salary.
Page 2.
Page, my lord, 42. Page 42.
Read petition order.
This order, yes, my lord, read petition order.
Page 42.
Yes, my lord.
Yes.
The at the bottom, my lord.
Yes.
The petitioner, in order to substantiate the claim, has filed a supplementary affidavit annexing a salary certificate of a deceased husband issued by the college. That is not. That is only I have filed a my lord RT information from RTI. That is not a salary certificate. The certificate indicates that even in the month of April 2099, her husband received rupees 6,882, and the month of June 2008 he received 17,341 as his salary. That is a lack of authenticity, my lord. That is the lack of authenticity.
What lack of authenticity?
Because they give only, this is not a salary certificate. Only
did Madhusudan challenge the order of rejection during his lifetime? He did not.
No, in the year 2017
he challenged.
Yes,
that was rejected, sent to the authority for consideration. Authority rejected it by an order of 2000 or 8th May 2018. He died in 2023. From 2018 to 2023, you did not, Madhusudan did not challenge. Thereafter, the widow came up and filed the writ petition.
2017, my lord, Madhusudan challenge.
Yes, that was.
But, and in reflection that order, my lord, Joint Secretary passed the order. That is also erroneous order. Why I am telling you, lordship?
So, Joint Secretary passed an order on 8th May 2018.
18.
So, that order is erroneous according to you.
Yes.
But Madhusudan did not prefer challenge the said order.
That is the latches and
তাহলে আর
lacuna
কোত্থেকে
on the
দেবো
part
বল?
of this, my lord.
Where from we will give you any relief, Mr. Ahmed?
No, my lord, that is why, my lord, I challenge this.
Now, the crux of the matter is the amount was paid, the amount claim as ADR was rejected. That was not challenged by Madhusudan.
That was not challenged by my lord, live Madhusudan, alive Madhusudan. Yes, but that was challenged by the widow.
But she cannot do so when her husband did not challenge that order. He was satisfied with that. There is nothing, Mr. Ram.
এক জায়গায় লিখেছিল বলে যে ওই থেকে কম 1581 ওই পেনশন যে ওকে দিয়েছিল সকলটা খণ্ডন করে এখন সেইটা বেনিফিট করছে
খণ্ডন করে দিয়েছে
খণ্ডন করে দিয়েছে কিন্তু এই খণ্ডনের যে অর্ডারটা এইখানটা রিজিন অর্ডারে বলে
At the reason order bottom, my lord.
রিজিন অর্ডারে এক জায়গায় লিখেছিল 1581 থেকে ওইটাকে অ্যাপ্রুভ দেখিয়ে ওই সার্ভিসটাকে অ্যাপ্রুভ অ্যাকচুয়াল সার্ভিস হয়েছে 24/5/1999 সেই দিনই ভ্যাকেন্সিটা ক্রিয়েট হচ্ছে তার আগে প্রিভিয়াস অ্যাপ্রুভাল করে দেয় ওই যে
My lord, for a moment, kindly see page 70, my lord. 70, page 70, my lord. Joint Secretary passed the order. My lord, I am just telling you, lordship. It is a fact that, my lord, at the bottom, my lord, it is a fact that the length of the service rendered by the petitioner Sri Mukherjee with effect from 24/5/1999 up to date of his superannuation 31st August 2008 is falling short of 8 months 23 days to make him eligible for pensionary benefits. At the time, there is a point of consideration that he had rendered service to the college authority for so many years and ends up without having any retirement benefits, having no faults of his own. As such, looking upon the case of Sri Haradhan Mahato, WPST 184/2010, as well as the observation of the Finance Department, West Bengal, which condoned the period of 8 months 23 days to make the service of Sri Mukherjee pensionable as a special case in relaxation of normal extent rules. I direct the college authority to submit the case of petitioner afresh, considering his approved service with effect from 24/5/1999 as per government order and pay fixation made there under the Office of Director of Public Instruction, West Bengal. Therefore, thereafter, the Office of the Director of Public Instruction, the West Bengal, will take initiative to forward the case to the Office of Accountant General, A&E, West Bengal, for correction of pension payment order on the basis of last pay 31st August 2008 as per DCRB rules, counting only 8 months 23 days of his service prior to his regular appointment. Accordingly, the government order, this order 181 ILC dated 27/2010 is hereby cancelled. If this be cancelled, my lord, then how he is entitled to get pension? He is getting pension on the basis of that order.
You don't go to question that way, you will be in difficulty.
Pencil will go.
You are engaged in a post where the post, there was no sanctioned post. The post was.
But that order was not challenged, my lord, before the by the government.
Allow the court, you know.
But that order was not challenged by the government, by the higher forum. If challenged, then I don't say anything before your lordships. I shan't say, my lord.
What they will challenge?
Because the order of the Honorable Justice Devanshu Bosak, in which order the delay was condoned, the deficiency of fall short of service.
Yes.
Fall short of service was condoned by the Honorable Justice Bosak.
Justice Bosak did not condone. The authorities condoned.
Authority condoned. Joint Secretary condoned.
Joint Secretary condoned. Where is the order of in the writ petition which was sent to the Joint Secretary? Where is that order? That was by Justice Chatterjee.
That was by Justice Chatterjee.
Then where did Justice Bosak come into the picture?
No, well, initially, at the very first stage.
First stage one?
I am just showing you, lords.
The shortfall was
My lord.
found on.
My lord,
by
page
virtue of
61.
which
My lord, page 61, that is order of the Honorable Justice Devanshu Bhatta.
order?
Page 61, my lord. It starts from page 61.
That is, principal secretary first rejected the prayer for pension because you are not having 10 years continuous
Yes,
service.
my lord.
After that, that was set aside. Your
Deficiency of shortfall of my service that has been regularized.
very good. Now, after Justice Chatterjee passed the order, that order is for what? That is for the ADR salary.
ADR salary.
Now, the ADR salary issue was relegated to the Joint Secretary.
Yes, my lord.
Joint Secretary passed an order. This page 70.
Page 7.
Joint Secretary rejected the prayer for ADR.
My lord,
This order was not challenged by Madhusudan. After Madhusudan expired, after receiving pension and everything, the widow, after getting family pension, challenged this order.
yes, my lord. There is a lack of jurisprudence of law. The sun rises in the
Aggrieved by the
Which judgment you wanted to rely upon?
One.
Explanation, section 5.
উপরে এভিডেভিট অফ সার্ভিসেস ফাইল
Paragraph number 29.
evidence as file be kept on record.
Paragraph 29. With regard to explanation in section 5 condonation of delay application.
Explanation and
Explanation and excuse.
Excuse.
In this point, it was held.
Yes. But which has not been reported as reported. I have reported. Apologize. Explanation and excuse.
INS. Yes, next matter.
Grateful, madam. Would appear for the review applicants in this matter.
What is explanation or what is
There is a delay of 54 days in preferring this review application. And then, the report says that there is a
review. Okay.
this is because of the array of parties.
It should be memorandum, just like memorandum of appeal. Order 47, Rule 1.
But review at the instance of non-parties.
There is a delay.
There is a delay of, as per the reporter's report, it is 72 days, 79 days delay.
You want to oppose the delay?
I have to oppose the delay for the reason that in the meantime we have taken steps as per the judgment.
Then you file your opposition.
I just submit before your lordship. On the last occasion, it fell from the bench. If there are still vacancies and if the arrangement could be made to accommodate these candidates, you are supposed to come back with the instruction orally observed by this
That
bench.
is because there was a different bench on that day. That is why.
What did we direct in that order? They give appointment to
appeal, your
15,000.
lordships directed that there should not be re-verification of the process of those candidates who had already participated in the personality test or interview. After the interview, the commission wanted to reopen the cases of those participants through a re-verification process. Your lordships disapproved that action of the commission. But we say that we also stand on the similar footing, but the commission had filed an affidavit in connection with the appeal wherein they stated that after this personality test, they had re-verified our documents and found us to be not eligible otherwise. By reason of
your names were not there in the list of those, that chart which was prepared.
We appeared at the interview. So we are amongst those 233 candidates who had been left out from the final merit list by reason of certain ineligibility as alleged by the commission.
So that was left out even before the
We were interviewed subsequently. Now, your lordships disapproved re-verification after the second stage interview. We participated in the second stage interview or personality test as well. But because of that affidavit, your lordships directed.
Which affidavit?
They filed an affidavit in connection with the appeal saying that
they showed that 233 is excluded.
We were not parties, we were not informed of that, and not if the Honorable Division Bench has already held that this re-verification process is not applicable to 1585 candidates whom they have interviewed pursuant to your lordship's order. We also stand on the same pedestal. That's our short point before your lordships.
I see. Can you show us that portion of the order?
Paragraph 35 of your lordship's order at page 400.
No, this does not include that 233 exclusion. That was in their list.
In the
prepared that you bring that affidavit on record.
That's also on record.
Where is that page?
Page 226.
But the affidavit of the commission is at page 226.
226.
No, no, it was can two, can one. 26 of can two.
Of can 1.
এটা কি এটা তো আবার রিভিউ ক্যান ওয়ান
Can one section 5.
ক্যান টু ইজ অ্যান অ্যাপ্লিকেশন ফর অ্যাপ্রোপ্রিয়েট অর্ডার
This is an application for review.
with the memorandum of appeal.
Memorandum of review is separate, not there is a can.
Can one
Can 1.
can two বলছে can one is the section 5. In can two then the order must have been annexed also.
Yes, yes.
তাহলে
Page 400.
এই দুটো একটু না
Can 1. তো can 2 দেখছি আমারটা can 1 can. Please come to page 228. Note the affidavit begins at 226. Please come to 228, paragraph 5.
Two 28.
Internal page 3 of the affidavit.
Yes, Mr.
Being agreed by the orders, several appeals were filed, one of which is MAT 638 Rajiv Brahmo versus so and so. That was the appeal which was being considered by the Honorable Court. Was pleased to pass an order on 20th July 2021 giving certain directions upon the Commission with regard to conducting of the grievance redressal mechanism and preparation of panel. In compliance with the said directions, the Commission concluded the grievance hearing of about 18,536 candidates on one hand and held the interviews or personality test of 15,436 candidates on the other hand, though only 12,792 appeared for the same. Now please turn over the page to 229. As far as the personality test part is concerned, a total number of 15,436 candidates were called for personality tests, out of which 12,792 candidates appeared in the said personality tests. Out of the 12,792 candidates who participated in the said personality test, 253 candidates, but this should be 233, I believe, were inadvertently interviewed by considering the wrong test score, which after correction 6 candidates were found to be within the zone of consideration and the remaining 247 candidates were not, and therefore their interviews were to be cancelled as they were wrongly called for interview. Now this was the stand taken in the affidavit.
Now remaining how it becomes this 247 will also differ, na?
Yes,
that
the
calculation is not correct. No, it's kindly proceeds on the basis that it is 233
Kindly
candidates.
see paragraph 9, it will become clear, where we have.
Yes.
Now please come to page 309.
309. 309. Yes. No, you are 229. You do not want to show us
Yes,
para 9.
229 I have just now read before your lordships.
No, he was saying paragraph 9.
Paragraph 9, very well. May I please paragraph 9?
230.
230.
Yes.
For the above reasons, this Honorable Court may most graciously be pleased to allow the Commission to do the following so that the order dated 20th July 21 read with 10th November 21 may be complied with and the final merit list may be prepared and produced before this Honorable Court for further directions. But what do they want to do? 1. To remove the 233 candidates referred to in paragraph number 6 above from the interview list, as they were not eligible to participate in the said interview. We had already participated in the interview, as it appears from page 228. Then to upload the interview list with all details of 1585 candidates. Your lordships ultimately allowed these 1585 candidates to be considered without re-verification, who are now eligible to participate in the interviews or personality test, and also to hold the interview of the said 1585 candidates so that the final merit list may be prepared by the Commission. Now this is what they wanted to do. Now please come to page 309.
Now this removal was accepted by our earlier.
I'll show you, lordships. Please come to page 309.
Yes.
Paragraph 8. And paragraph 7 onwards. In compliance with the directions given by the Honorable Division Bench in its order of 30th September 2022, the Commission concluded all pending interviews, which included, in addition to the said 1585 candidates, 4 more candidates who had been inadvertently left out. The Commission also cancelled the call letter of 1 candidate who had inadvertently been called for the personality test. Hence, in the second phase of interview or personality test, a total of 1585 plus 4 minus 1, 1588 candidates were called for interview or personality test. But this is factually wrong. Please come to page 193. I'll come back to the page later on. Hence, the total number of candidates who were called for personality test by the Commission were 17024, first phase 15,436, plus second phase 1588. However, the total number of candidates who appeared in the interview or personality test were 14,052, first phase 12,778, plus second phase 1,507, less 233 ineligible candidates.
So they were excluded earlier, 233.
Earlier, yes. Second, we were called for the interview, we appeared.
But you were not there within 15.
We were not in 1585.
158. No, total appointment was given to how many? 15,000 something.
Yes. 14,339 was the final vacancy.
14,339. Now we directed that fill up how many vacancies?
Now 12,792 appeared in the personality test.
No, tell us the figure.
Final judgment, which is under review.
No, your lordships allowed 1,585.
14,052.
1585
were additionally allowed.
Additionally allowed.
So the total participants were 14,052.
14,052.
Appointed. After your lordship's order, 14,052 appointed.
Not appointed, that is continuing. No?
Final. Let us proceed on the basis of a final merit list.
So this 14,052 does not contain 233.
The 287 vacancies still remain.
Now, please remind us 1585.
Please come to page 400, but this will immediately come back to your lordship's mind.
So, Mr. Mojumdar, this 233 which you are saying, they were not parties to this proceeding. No. So what were they were sleeping?
But the list was published only in September and we immediately filed this review before vacation.
September, to in terms of our order. So we said publish.
Your lordships allowed 1585 candidates on the ground that re-verification is not permissible after interview. But they say in their affidavit that we were called for the interview.
Achha, please remind us.
Please come to page.
We are not party to the
read petition is party.
An appeal.
We were not parties. But this is review by non-parties in the proceeding.
No, there was an order, if I am not wrong, of Justice
Talukdar, I have an
approving that 233 exclusion.
Please come to 234, 304. I'm sorry, 304. It does not exclude. The order does not exclude.
Any person, yes.
Any person.
But had these been brought to your lordship's notice, not your lordship's not, we would have also not sailed through. Please come to 304. That is part of his lordship Justice Talukdar's order.
No, please let us go through what later our.
Your lordship's order. Yes. Please come to 398. Not paragraph 34. Have your lordships kindly got that? After cancellation of the selection process by the judgment dated 11th November 2020, that's the Honorable Single Judge's order in the first round. The Commission was directed to hold a fresh selection process of all the candidates who are found to be eligible under Rule 12.2, which pertains to preparation of lists of eligible candidates for the purpose of preparation of a computer-generated database of all the candidates. Thus, the quantum of participants in the selection process directed to be continued from the stage of 12.2 remained unaltered to be tested for appointment. In the said conspectus,
allowing the same set of candidates to compete for vacancies included in the earlier final vacancy list, together with the newly created vacancies, would enhance the scope selection for the candidates enlisted
That was
under
for scope of
Yes.
the number of vacancies.
No. In course of hearing of the present appeals, the Commission affirmed 4 supplementary affidavits on so and so dates respectively. Not one of the affidavits is 12 September 22. In the said supplementary affidavits, it has been disclosed that the final vacancies as on 11th November 2019 were 14,339, excluding 10% vacancies reserved for para-teachers. In total, 2,28,660 candidates applied. Upon considering the said applications and upon conducting personality test, a merit list was finally published on 4th October 2019. The same was ultimately set aside by the judgment on 11 December 2020. Proceeding afresh for selection of candidates, the Commission published an interview list consisting of 15,436 candidates with all details on 8 July 2021. The said candidates were thereafter called for personality test, amongst whom 12,778 candidates appeared.
So you are coming within this.
Yes. In the second phase recruitment selection process, up to the personality test, we appeared on being called at the interview.
No, called, you were called for personality test.
Page 193.
Then why were you excluded?
Now comes not the explanation of Commission. Thereafter, in compliance of the orders passed in the writ petitions from which the present appeals have been preferred, 18,436 candidates were called for grievance redressal hearing. 3,329 candidates were absent on the date of hearing, and another list was published on 15th October 2022 consisting of 1,585 candidates who were called for personality test upon obtaining leave of the Honorable Court on 30th September 2022. Please come to the order of 30th September 2022. The order does not grant any leave.
No, anyway. So you came into you were within those 12,778 candidates called for personality test. You were also called.
We were also called for.
Now, why were you excluded?
Not because they say that there was a mismatch in the TET result. TET marks, there was a mismatch. Apropos the e-mark sheet and the database. So they conducted a re-verification after the personality test.
So show us, this point was in one of the coordinate benches order that we want to exclude 233.
That is that what, yes.
Commission said that 233 is to be excluded.
But I have shown to your Lordship the opposite, the affidavit of the Commission. Now, he says that apropos the leave granted by the Honorable Court in September, on 30th September 22, we were not considered. But that's the middle, almost the middle portion of this paragraph 35. Now please come to the 30th September 2022 order. That's at 299.
Which page?
His Lordship's order, that is at 299.
So your names were not there in the final panel?
No.
After the declaration?
That's why we are in review.
299.
299.
Yeah, what's showing?
No, there are available vacancies even after the carriage of this interview.
And they will, how you can topsy-turvy with this situation?
No, I am not topsy-turvy. No, there are available 287 seats still left vacant. I am 34 review applicants before your Lordships.
No, they are giving, now they are going to the stage of
14,339 declared vacancies, final vacancy. They have prepared a list of 14,052. So 14,339 minus 14,052 is 287.
In which you can get?
I can fit in. Not in terms of your Lordship's judgment at paragraph 35.
No, we didn't say that.
No. I say I draw analogy. I draw spirit from the judgment.
Oh, now you add that word spirit. That's a nice way of putting it. Yes, to remove paragraph 9 says page 299.
Yes. Dr. Patro, learned counsel, but it's somewhere in the middle portion of that page.
Yes.
299. Dr. Patro, learned counsel appearing for SSC led by Mr. Dotto, learned senior counsel, draws our attention to this to paragraph 9. Not that paragraph 9 I have placed.
This is in page paragraph
228 and
229.
229.
And 229.
Accordingly, on the basis, not at 300, after that quotation, accordingly, on the basis of paragraph 9, read with paragraphs 10 and 11 of the said affidavit, learned counsel for the SSC seek the leave of this court to conduct the interview or personality test of the 1585 candidates who have been found to be eligible to participate in the interview or personality test. In support of such prayer, the SSC relies upon two orders of the Honorable Division Benches on 20th July and 18th May 22. It is submitted on behalf of SSC that by the order dated 20th July 21, the Honorable Division Bench was pleased to direct the SSC to proceed with the selection process of upper primary teachers and inter alia identified 7 steps to be followed by SSC for conducting such process. It was also specified by the said order of 20th July that SSC shall place both the combined merit list of the candidates actually interviewed in terms of the directions given above, as well as the database reflecting the redressal mechanism of the aggrieved candidates before the Honorable Court for further directions. Please take note of the words on the basis of the database. If any, the SSC should also maintain at its disposal for production before the court as and when necessary the original database of the merit listed candidates existing at the time of filing their applications for selection in 2016. By the next order of 18th May 2022, the Honorable Division Bench was pleased to clarify that the grievance of 1098 candidates to be uploaded along with their academic records for consideration by the SSC. It is now submitted on behalf of SSC upon filtration in terms of the process as specified by the two orders has arrived at the stage for consideration of 1585 candidates for the interview or personality test in terms of para 9 of the affidavit. The SSC has submitted that it should be allowed to go ahead with the personality or interview of 1585 candidates and place its report before the Honorable Court in terms of the order of 20th July. But the next paragraph is also
where
submission.
is that portion that 233 excluded?
Please come to not page 304. No, that's the ordering portion.
Yes, selection process.
Having heard the parties and closely considering the materials placed, this court at this stage is of the view that the selection process as directed to be carried out by the order of 20th July and 18th May are interim in nature inasmuch as the SSC in terms of the said orders is to produce the merit list and the database before the Honorable Court for further consideration. Accordingly, this court again at this stage is of the view that the appellants do not stand deprived of the opportunity to test the interim findings of the SSC upon compliance of the earlier directions of the Honorable Court. Before parting with this discussion, this court must also notice the anxiety expressed by both the appellants and the SSC and recorded by the order of 20th July seeking expeditious conclusion of the appointment process. In the backdrop of the above discussion, the SSC is permitted to complete the personality test or interview of the said 1585 candidates as stated in its affidavit and subject to compliance of the directions of 20th July 2021 as clarified by the order dated 18th of May 2022 and without prejudice to the rights and contentions of the parties. Now, if the database of the commission is something which they wanted to rely upon, they can't, number one, they can't go back upon their own declaration before this court or stand before this honorable court. And number two, your lordships in paragraph 35 of your lordship's judgment have specifically debarred the commission from exercising a re-verification process after the interview for 1585 candidates who were before your lordships.
But that 1585 does not include 230.
No, it doesn't. I seek inspiration from the analogy of your lordship's judgment in paragraph 35. If re-verification after interview has been held to be...
Why didn't you come earlier, Mr.
Not the
merits will be reopening of the Pandora's box. We don't know if we reopen how many new persons will come in.
That's the sole affidavit of commission. The 233 were left out. But they have not talked of any other candidate.
How many times we will revisit?
It was for the commission to
file a fresh writ petition.
Today, not with
vacancies are existing.
Yes,
go to the writ court and file a fresh writ petition.
Today, your lordships, there are two ways. Not one, I can file a review.
Mr. Mojumdar, the review, we are apprehensive of this fact that we have closed a chapter. Now there, if you find that some parties were not added as such, some arguments could not be made, which could have included this 233. This you are trying to re-argue before us in the review bench.
As a non-party.
As a non-party. So we don't find, why don't you give a thought to this? Go to the file a fresh petition on the basis of our observation.
I could have, subject to not this commission's stand having been taken on record before the division bench.
Yes, Dr. Patra.
May I just say a few things? Number one, out of 233, only 34 have come up in review. So the bulk of 233 are not before your lordships. Number two is they have come at such a belated stage. My learned friend cannot simply go by the order and presume what are the vacancies. We have completed 2 rounds of counseling. We have already done the counseling of 11,500 and odd candidates out of the 14,000. So we have almost completed the process, and now they want to come in claiming that they were non-parties and ignorant when they latest possible date by when they could have become aware of the fact that they were excluded, giving them the maximum benefit, is when we uploaded a provisional list in 2023 without including them. They did not come to court
in
2023.
That is after Justice Talukdar's order.
Yes. Now,
so that list did not contain the.
We were permitted to upload a provisional list.
No, Dr. Patro, if 233 had already been personality tests, they have appeared.
Yes.
Then you are, what is the ground of
your lordships will
exclusion
recall? Your lordships will recall. Why have they been removed? We wanted. We had made an endeavor to check the TET answer scripts of the candidates and to see whether the server marks and the marks in their e-mark sheets were correct. Now, if we avoid all the complications of the litigation, because there were so many ups, downs, twice we published provisional merit lists. Lastly, we published the final list on the basis of which the selection process is now almost concluded. So, these 230, what your lordships finally directed.
ওদের মধ্যে কেউ বেটার ভ্যাকেন্সিতে এন্টাইটেল হতে পারছে, ওটা ঢুকে গেছে।
পরে 3 বার হয়েছিল, আমাদের সুপ্রিম কোর্ট এসএলপি ডিসমিস করেছে, সিভিল অ্যাপিল হয়নি।
তুমি আজকে 34 কে যদি পরের দিন আবার 200 জন আছে, যে আমি পাঠাচ্ছি। Final published list is there. If we pass any order in your favor, you have to be inducted in your respective levels in the final published list. Then they will consider you. This will topsy-turvy the entire situation.
But I have a submission to make for your lordship's kind consideration. 14,339 is the declared final list.
Admitted, vacancies are there. So you go and obtain an injunction as regards the remaining vacancies, and they are also not minded to do so, because the reporting as it has been done, it says that many persons have opted out of the process. So further vacancies has occurred, which they will be filling up from the second list or what
wait list, not whatever.
Wait listed candidate.
We are not even in the wait list because of non-consideration.
Yes, exactly. So you have today, if we give you this permission, tomorrow another 5 persons will come and say, extend the same benefit to me. This will be an it will be an ever-going process of interference.
Your lordship's, not your lordship's judgment. Not
so, Mayundar, apply your Apply your strength on the basis of fresh reports.
But I can seek your lordship's leave then.
Leave for what?
But so that the affidavit used before this honorable court has been taken into consideration while delivering the judgment. This may be a stand taken before the honorable single bench.
Right, but your exclusion therefrom, you are not parties to them, you are not guided by that order.
No, that is the point I take before your lordships by way of a review application. I could have filed a separate writ
Your
petition.
scope of challenge is narrow here, Mr. Majumdar.
No, not just because not if your lordship makes certain or not makes an observation that these 233 have not been considered and it is left open. Because not his lordship Justice Talukdar, while pronouncing that order on that judgment, said that at this stage and it is an interim measure. Number one, 1463 candidates were before your lordship's court, which your lordships allowed that no re-verification is permissible.
Right, but you are not there, no, Mr.
We were not there. So, not,
So you
my
ought to
fate
have
gets
been-
sealed
My lord,
by
may I-
reason
may
of
I
an
just-
affidavit used before the division bench, of which we were not aware. And that appeal was
Interrupt.
Dismiss, you can withdraw, we will give you the liberty to approach the writ.
Appropriate forum.
My lord, before that.
Not the appeal was at the instance of persons who were not called at the interview, and we were called at the interview in the second phase.
We understand your grievance. Now, the thing is that suppose today we pass the order accepting your contention, this will it will again topsy-turvy with the entire situation. So process subject to what you are thinking, if the process after being concluded, there are more than 300 vacancies left, so that they cannot fill up those by a fresh in the carry forward rule, they do not apply to that. And if you have been interviewed, then I don't think there will be any problem. But to give you that benefit in the review, in the limited scope of review, subject to what you argue, Mr. Majumdar, I think that might be difficult.
My lord, may I interrupt? May I-
ওটা দেওয়ার অসুবিধা কি?
Two
We
things.
will give liberty to
For
them.
1.5 years, they are aware that they were,
They
because we
for
published, I have
for
the
8 years,
notification.
Dr. Patro, everybody was struggling. Now the matter is being resolved.
Second aspect, what was the short observation of the Honorable Division Bench while passing the final order? That the commission did a mistake by reopening the OMR sheets and that we have to go by the e-mark sheet. That was the final observation. We cannot recheck, re-examine, review the marks. So we went purely by the e-mark sheets. In our previous affidavit, which my learned friend was placing, he did not place the annexure. We have shown there that in case of each of the candidates, all 233 candidates, they were all below the cutoff while considering the e-mark sheets. And that is why, while finally doing it, let us ignore all the events which happened over the last 3 years. I have also prepared an affidavit, though on the last occasion, no order was passed upon me, but my lord had directed me to take instruction. The nature of the instruction is such that I cannot place it without an affidavit. So I have prepared an affidavit annexing the list of 233 candidates, all including these 34, showing their e-mark sheet, TET weightage calculated on the basis of e-mark sheet, because your lordships have directed
Now
us.
they are coming within the zone.
No, they are all below the cutoff. One has become disqualified and the remaining 232, they are all below the cutoff. That chart we have prepared and annexed. Kindly just see the chart. Your lordships did not read the affidavit.
So, Dr. Patro, this will create difficulty for them to get an order from the writ court if we take it.
Yes, that is correct. But there also I will be taking the same stand. They can go before the writ court. I will have to fight it
But
out
I invite
there.
your lordship's kind attention to page 301. And how many stands will the commission take before different courts?
Have you handed over this thing to?
No, because there was no direction. I do not know whether your lordships will allow me. I can give a copy.
Affirm it? No, not.
Yes, it is affirmed.
301.
So these persons do not come within the cutoff to be in the final list.
Lordship. And since your lordships have directed.
Then how they were called for the interview?
That is the thing. That is why ultimately when your lordships directed us not to look at the OMR sheets, not to go by server marks, to check on the basis of the e-mark sheets, since they were already rejected on the basis of e-mark sheets,
So
we
that
did
is-
not
No,
bring-
that which Dr. Patro, you did not point it out to us that apart from this, there are 233 candidates who would also not be excluded since the court is taking up this stand. Then we could have passed that order.
No, they were excluded because they're below the cutoff after taking into consideration the e-mark sheets.
Then why did you call them for the interview?
That was the mistake or the wrong of the commission initially while conducting the interview.
Answered by your lordships at paragraph 37 of the
Just
judgment.
like we had wrongly excluded the 1585,
Please
which your
take-
lordships directed us to take back.
Please take page 301 and
So
page
we can take back, but
402.
we cannot
Please take 2 pages
send
side
them
by
out
side.
if they are ineligible.
But varying standard, various stages.
All right, do one thing. Unofficially, we are asking him to give a copy to you. You go through that copy and think over this as to whether it will be profitable for you to go for a writ or not upon taking liberty from us.
Not
And
kindly,
if you still want that, no, you will insist on the review, then we will
not, we can go back. Not kindly recollect, not Shivdev Singh, a writ petition is maintainable to review a judgment, but
Yes.
not before you, this is before a division bench that this
will not be you will not be reviewing our judgment. Your ground will be different in the
different. Now, not, there are vacancies available where not we take not
Yes, there are
encouragement from your
vacancies
lordship's judgment.
It is a fact that we were interviewed. On that analogy, you give us subject to what objection they take.
Not kindly have a, I was not apropos the supplementary affidavit or the opposition which my learned friend must have prepared. But I was just drawing your lordship's kind attention to 2 pages, 301 and 402.
Yes, 301.
Not internal page 7.
So, Mr. Mojumdar, we will go through that.
Very
If you take this decision, then why should we unnecessarily
Not
go
if your lordship kind of makes this observation that I am at liberty to go back before the honorable single judge, but I'll come back on another day after taking an instruction.
we will dismiss it as withdrawn with liberty to you to prefer take appropriate steps.
Have you got the copy?
Yes, yes.
I have to give one copy to Mr. Mujumdar.
This is not a secret document. You can give
No, because the annexure was already annexed to the previous affidavits also.
Then Dr. Watson, do one thing, give a copy to him.
Yes.
We are not taking it on record because if we take it on record, then we have to deal with it. No?
Your lordships can take it on record and then not rely upon it while sending it back to the single judge.
Acha, heard Mr. Mojumdar and the advocate appearing for the applicants.
While I going through the judgment of this, I am the appellant of this matter.
কি হলো?
While I going through the judgment, several names are not found in the certified copy of the judgment, who had party before through the application, addition of party.
Several names
Names
were-
are not there.
So what will our officers do, sir? It was your responsibility to point it out to our officers.
The advocate on record constable type.
No, when you are added, the office was directed to make necessary amendment
Yes,
of the cost title.
I also give them the
You take out this order and go to the officer concerned. Okay, I think the problem will be solved.
Yes, next. This is 9, 10, 11, 12, na? Mr. Mojumdar, you are 9, 10, 11, 12.
11. Item number 11.
শুধু 11, আচ্ছা আচ্ছা। এটা আবার next one also yours.
No,
12.
item 11. I'm only.
Well, my lord, I appear for the national.
My lord, I am appearing on behalf of the appellant. My lord, I am led by Advocate Firdaus Shamim. My lord, this is a NOC brief. We have just received it today, my lord.
Do you know the previous history? You are making this submission?
My lord, I have been in.
No, you must not be knowing. The gentleman who is standing behind you, he, in spite of adding an engaging an advocate, mentioned before us in person. Our court hour is being wasted by making him to understand that, sir, you cannot do so. Next day again he comes with another advocate. Again we give him the indulgence that keep it today. And now today you are saying I am newly engaged. Probably this thing will not be beneficial to anybody. He must understand that. He knows everything, maybe he is doing something. I don't know why. Just because we are giving indulgence, that is why he is doing or not, we don't. Now, Mr. Roy was not there. Nobody was there. Review came up. Review, you are not listing it in the matter. So we said, where is your counsel? Please allow come. He says that I cannot bring my counsel. You listen to me. We listened to him. We said, all right, even if there are infirmities, keep it. We kept it. Then one advocate appeared. Have you been engaged?
Yes, my lord.
Don't know that. You must be speaking for somebody else.
Well,
who is your senior?
My lord, Advocate Firdaus Shamim, my lord.
Mr. Firdaus Shamim.
Yes,
Have
my
you
lord.
executed an wakalatnama in this?
My lord, today it has been filed, my lord.
It has been filed by whom? Who is the advocate on it?
My lord, Advocate Gopa Vishwas.
She is also not here.
My lord, she is in room number 35, my lord.
Adjournment has been prayed for. Give your name. An adjournment has been prayed for on behalf of the is there, Mr. Roy?
But
State is there, I think, represented by Mr. Tapan Mukherjee.
Yes. Yes, doctor. হ্যাঁ। না না, এটা কি ওই যেই ছেলেটা আগে বিয়ে করলো? ওই দেখা ওইটা আগেরটা কোথায় কোন দিনকে ফিক্স করেছিলাম? এটা কত 27 তারিখ হলো? হ্যাঁ, heard the learned advocates appearing for the respective parties. You are there in this item number 13. You are there.
Yes, my.
List the matter for further consideration in the daily under the same heading in the daily supplementary list of this court on 27th February as fixed at 2 p.m.
My lord, we are for the added respondents. We have filed an application, but we have not been yet added.
My lord, same prayer is also filed.
What?
My lord, we are for the we are seeking to be added.
Applications are already there.
My lord, there.
Very good. We'll dispose of everything.
My lord, with regard to item number 14, my lord, 2 p.m. My one matter is fixed in another court. Can it be accommodated, my lord?
Ask your junior to tell us.
Junior to.
27th February. I appear for the respondent. Item number 30.
27th February.
27th February at 2 p.m.
At 2 p.m.
No.
But when I stopped, I was at page 51. So I would begin from page 51. That's the rule. Well, 51 is the 2019 rule itself.
You are appearing for the
promotees.
The writ petitioners.
Like the writ petitioner.
Who is for the writ petitioners?
My lord, some of my other learned friends.
Well, 493, I am for the petitioner.
Yes, similar.
Yes, yes. Similar.
Yes. Page 51.
Yes. Lordship, may kindly see this is the notification, that is the rule. Now, first, my lord, I would be placing that this rule is only for the purpose of recruitment. So therefore, if there is a recruitment, this rule is a relevant rule. Anything other than the recruitment, this rule has got nothing to do.
Yes.
For that, my lord, the first paragraph itself, in exercise of powers conferred by the proviso to Article 309 of the Constitution of India, and in supersession of all the previous rules on the subject, the governor is pleased hereby to make the following rules regulating the recruitment to the post of supervisor of Integrated Child Development Services Scheme. So therefore, I am on rules regulating the recruitment to the post of supervisor. Thereafter, my lord, kindly take the second paragraph. The method of and the qualification required for recruitment to the post. My lord, I am only on these two words, for recruitment to the post. So the method under the rule prescribed, it's not a method for anything other than for recruitment. Second paragraph, first line, the words for recruitment. Now, my lord, rule 3, method of recruitment. By direct recruitment, 50% of the posts. Well, I'm not reading others. Now, Lordship may kindly see the words posts as different from the words deliberately not being used, vacancy. So direct recruitment is 50% of the posts, and promotion out of remaining 50% of the post of supervisors. There is a 45-5, but that is not relevant here. So my submission is that the rule is exclusively for recruitment. Method of the recruitment says 50% post for the direct recruitment and remaining 50% for the promotion. Now, my lord, the note, which apparently looks like as if it is against us, but I might be able to persuade your lordship that this is not against us at all. Note, in case of vacancies, lordship may kindly mark the word occurred up to 30th September 2015. I'm not reading rest because then they say it's 75-25. My submission before your lordship is this: the word occurrence has to be understood in the context of a recruitment, which is the purpose of the rule. In other words, existence of vacancy
Yes.
is not occurring of the vacancy for recruitment. Now, there is a direct judgment by a full bench judgment of our court on that. 2019 SCC Online, Calcutta, 381. There, your lordships, Justice Dotto and Justice Saraf, first your lordship's view, it was again 2019 SCC Online, Calcutta.
Recruitment and selection are different.
Yes. And then their words, first it was your lordships, then it was endorsed by Justice Dotto, and it was exactly echoed by Justice Saraf.
Maybe mine was not strong enough to stand that.
But then it was scrutinized by Justice Dotto and Justice Saraf. Well, paragraph 38. This is your lordship's words. Kodamtala High Madrasa.
Yes.
Paragraph 38. The term selection means exercise of discretion of the members in the selection committee in examining the participants. The candidature of the aspirant cannot be construed to have been considered on the date of creation of the vacancy or on the date of issuance of prior permission, since the said two dates are prior to invitation to participate in the interview. The selection process cannot be construed to have commenced on the said dates. It is only on the date of advertisement, when the candidates are invited to apply. The selection process commences and the fourth issue is accordingly answered. Lordship may kindly take paragraph 42, Justice Dotto. I am in complete agreement with the learned Advocate General that although ordinarily the words recruitment process and selection process are used interchangeably, the same are not synonymous. Paragraph 42.
Yes.
I am in complete agreement with the learned Advocate General that although ordinarily the words recruitment process and selection process are used interchangeably, the same are not synonymous. By and large, a selection process is an integral part of a recruitment process that an employer initiates to fill up vacancies by open selection. While recruitment process starts with the decision to fill up, and I am on decision to fill up an identified number of vacancies in the manner prescribed, and ends with appointments in favor of the selected candidates. A selection process could commence with a requisition of names of eligible candidates from the relevant employment exchanges and the issuance of a public advertisement, or even thereafter, depending upon the language of the governing rules. And normally a selection process would terminate with preparations of the final panel merit list. Now 47 is Justice Saraf's. Question number, paragraph 47. It is paragraph 46, last paragraph. This should be, my lord, page number 13. The pagination is very difficult to read. Last paragraph. D, question number 4. As to when a selection process is commenced, whether with the arising of vacancy due to the death, resignations, or retirement of the incumbent to the said post, or with the creation of new post, or when the post is advertised and candidates have been called for interview, or after the interview is held. Answer: the selection process would commence only after the advertisement asking candidates to apply for a particular post. Now, Lordship may kindly come back to page 51 of the rule. Now, this is a full bench judgment.
Yes.
Now, my lord,
You formulate your
yes,
formulate
yes. My first formulation is a note in a statute cannot control or override the substantive provision of the statute. That's my first formulation.
Yes.
For that, I say, if I can say thereafter, I show.
Yes.
I say that the legislatures wanted this so well. That's why they have used 50% in respect of a post. So therefore, if there is a cadre, in this case, there are 4,000 and odd, I think 4,900 and something. That's the total number. So legislatures wanted that I am creating a rule by which the 50% of the total number of posts should be for the direct recruitees, and the remaining 50% should be for the promotees. This is a substantive provisions of the statute itself. Now the note says, if I read
of vacancies.
Yes, note says in case.
What is your argument?
Yes, my argument is, note says in case of occurring of the vacancy, meaning thereby in case the occurring in the context of recruitment process starts, vacancy arose 2015 should go by 75/24. Number one.
So occurrence has to be
in the context of the first paragraph of the rule itself. Under Article 309, this rule is for recruitment to the post. It's not addressing the existence of the vacancy. And your lordships in the full bench have clarified it when it commences.
So the vacancies have to be in the context of the recruitment as per the rules.
Yes.
So that that answer will negate what? What is the other side of the coin?
The other side of the coin would be what my learned friends would be saying, that creation of the vacancy itself, not in the context of recruitment rule. So the other side's ballot, if I am for the other side, and if I have to refute my argument, I would say any vacancy, if it is created,
irrespective of when it did occur.
Yes, irrespective of whether recruitment process was initiated or not initiated. That, in my understanding, that would be the best argument. That I don't mind. The note says that I would take the English meaning of the word occurrence. So occurrence means the date of birth. I mean to say that when it is born. So any vacancy, if it is created 2015, this 50/50 will not apply. That would be the best argument against me. But then my answer to this argument would be, the substantive provision of 50/50 is for the post, meaning thereby this is the ceiling. No matter what is the number of vacancy, the substantive provisions of 50% for the directs and the 50% for the promotees cannot be tinkered with.
It has to be 50/50.
It has to be 50/50. Because otherwise, I would show that otherwise this two things. The word post would not have been used. And number
let us read the note. Note says
Yes.
that in case of vacancies occurred up to 30th September 95. So what is
2015.
What is your argument pertaining to the note?
My argument pertaining to the note is this, that the occurrence of the vacancy
No, the note says that in case of
No, first Lordship
vacancy,
said this is a note of what?
recruitment.
This is the note for a recruitment rule.
But let us read the total of
Yes, yes, I'm reading total. Right, right. Correct. In case of vacancies occurred up to 30th September 2015, comma, the ratio of direct recruitment as indicated in Rule 3A, right, and recruitment from the category of a Anganwadi worker and case workers as indicated in 3B taken together will be 75-25 ratio respectively. And in case of vacancies created thereafter, ratio of directed, but thereafter is already covered by substantive. So first part, if I make it in this simple way, note says in case of occurrence of vacancy pre-2015, ratio should be 75-25. In case of post-2015 vacancy, it should be 50-50. That's the note says.
That is what the trial judge has also said.
No, trial judge has taken a view in our favor. Trial judge has said that it should be 50-50. So we are supporting the judgment of the learned single bench. Learned single bench has very correctly understood this and directed that it should be 50-50.
So post September 2015.
I say, I have the other points, but
so how that analogy matches with your argument? If you distinguish between recruitment and selection,
yes,
that will not match with the order, which goes in support of you, as you are saying.
My lord, it matches in this way, like devil's.
You are saying that recruitment and selection are two different things.
Right.
Recruitment as notified means recruitment itself,
yes,
irrespective of creation of vacancies. But note incorporates a rider to the effect of creation of vacancies.
Yes.
That you say has to be read with the recruitment.
In the context of a recruitment.
In the context of the
Now, why I say this? May I say this? I would say both sides. Now, I don't because it's a point of law. I'm
not being able to understand. Yes. The trial judge has said that it will be 50-50.
Right. So substantive provision.
Now 50-50 pertaining to which vacancies?
50-50 pertaining to the law says posts.
No, what does the trial judge say? Let us come to the judgment of the trial judge, Mr. Dhar.
Yes.
Was that portion? The trial judge.
Well, at 50-50. Lordship may
kindly say 50-50. Pertaining to which vacancies?
Well, 50 page.
Prior to September 2015, 75-25. Now it has been brought down.
May I say this? I think my answer I would be able to give better from Mr. Bandobada's chart itself. There is a clear-cut answer. Kindly take the chart at page 40.
Now, first, tell us now what is your interpretation of this direction? Page 62. Accordingly,
may I come to page 62?
The court has said 50% of the vacant posts of supervisors will be considered for promotion.
Lordship is at page 62. Which paragraph?
Penultimate paragraph.
Accordingly, this court directs that Anganwadi workers to be considered for promotion in respect of 50% of the vacant post of supervisors.
At what juncture?
The total, now that juncture is coming. The total number of which is 3458. Their chart will show that 3458. That number was brought in 2009 itself. So vacant.
7th of March 2019 memo, which was challenged.
Yes. Yes.
So court says 50% of the vacant post of supervisor, which the total number of which is such and such, will be handed over by the court by the state, will be for promotion.
The reason being, page 40 of their chart would clearly show. It was not shown before your lordship.
345 has occurred
in 2019 itself for the purpose of recruitment. May I go there directly?
Yes.
Because I was also surprised after reading that. Kindly take 40.
Page 40.
Yes, that's the chart what Mr. Bandyopadhyay has relied on. Serial number 9 of the chart. When this number of posts were sanctioned, kindly take serial number 9. First I read number of supervisors sanctioned as in January 2019, 4958. Now, number of supervisor in posting, so those are working, 1,500.
The cutoff was 15 September 2015.
But cutoff was 15.
2015.
Yes. So all I am saying, there were existence of vacancy of about 3009, for which
where do you get that figure?
that figure can be found. Lordship may kindly see serial number 6. A mere existence of the vacancies for which never any recruitment process was taken at all. And that's why a sanctioning by the cabinet was taken in 2019 that we want to go for a recruitment for 4,958 number of vacancies. Once that is done in 2019, post rule, only logical corollary would be that half of 4,958, the half is, my lord, 2479.
No, but in the writ petition it was 3376.
That is, there are some other calculations.
Achha,
So lordship
but
may
3376 is proper.
Yes, yes.
3376 as per the notification. Now, when the advertisement was made, that was 3376.
But that I'll address when I show that. Before that, lordship, all what I'm trying to say, I say that by their own document.
We understood. Yes. By their own document, the number of vacancies existing as after September 2015 was this much. As such, it has to be 50s to 50. This is your
yes. And I say that serial number 9, the word sanctioned in January 2009, sanctioned. And serial number 10, supervisors who are already working. So 4,958 is the total cadre strength, if I can use that word, total number of posts, out of which 1,500 persons are already working, meaning thereby 4,958 minus 1,500, result is 3,458. That is the creation of vacancy for the purpose of or in the context of a recruitment in 2019, which has got nothing to do with lying or existence of the vacancy in 2015.
Yes.
If I just, let's say, one more sentence on that. For any recruitment, first, my lord, there has to be a cabinet decisions, or it can be called to be a sanctioning. Yes, I may have 5,000, I as a state may have 5,000, 10,000 number of vacancies. But state has to take a decision that we want to go for a recruitment for X number of vacancy. My submission is, once that is done, then the context of recruitment comes. Had there been a case that before 2015, there was a notification for filling up, let us say, X number of vacancies, I can say by giving concession on a point of law, yes, by note, that may be reserved for 75-25 ratio pre-2015. But that situation does not and cannot arise because of serial number 9 of their own chart sanctioning of 4958 and existence of working is 1949. So 3009 is the, now is, if I use the statute smelled word, 3009 is the occurring of the vacancy in the context of the recruitment rule. So once that occurring of the vacancy in the context of the recruitment becomes 3009, half of the 3009 is for the direct, half of the 3009 is for the promotees. That's the rule addresses. Now, Lordship, I have said this, but I said that 2004 13 SSC. Note 2004 তারপরে 2005 দুটো
Vacancy notified. Now, in the advertisement, how many vacancies did they notify?
Yes, Lordship, what we challenged, that would show that.
You challenged 7th of March 2009.
Yes, kindly see, we challenged page 31.
Page 31.
Yes. And that would also again show the cabinet decision. That's a very initiation of the recruitment process.
So the vacancies notified were there 38. Total vacancies that 3376.
Yes.
That is 422 plus 295.
Yes. Lordship, kindly take page 31.
So you have challenged this because this has been done in the ratio of 75-25.
Yes. And that I have calculated. Now, if it is to be followed, the ratio becomes the promotees. If I can place it and then I give the calculation. Kindly take page 31. It becomes 87.5% and 12.5%. Total violation of the rule itself.
80, from where you are getting 80?
Kindly come to page 31. Kindly take first paragraph, then I'm saying.
Yes.
I am directed to inform you that 55th meeting of cabinet held on 21st February 2019 has approved VD number such and such, Roman 1, recruitment rule for the post of supervisors under ICDS.
That is
that's a sanctioning.
That 25th February.
Right, yes. And Roman 2, filling up of vacancies of, this is the 3376 post of supervisors on the newly framed recruitment rule, of which 422, now Lordship may kindly mark, this 420 numbers post will be filled up by promotion, that becomes only 12.5%. By selection from Anganwadi workers under ICDS, case workers under control vagrancy, the remaining 2,954, that becomes 87.5%. So in 2019, cabinet is approving. 2019, it is post.
This is not 75-25.
No. This is a complete fallacy.
This is 422.
422 equals to 12.5%. It is 422 divided by 3376 multiplied by 100.
2954.
It is 2954 divided by 3376 multiplied by 100, 87.5.
So these also do not tally with their
substantive provision. Yes. Lordship, may kindly see if the
না সেটা তো এখানে স্পেসিফাই করছে না, এখানে শুধু নোটে বলে কোন ব্যক্তি
ওই হিসেব থেকে হিসেবে সার্জেন থেকে হিসেবটা ক্লিয়ার সেই চার্ট Why is that chart?
59.
Page 40.
Page 40.
Yes. My lord, someone who has made this chart.
Now, who has given this computation? This was called for.
This is by the state on the basis of an order. So it's on affidavit. And on record, there was no recruitment process being initiated between 15 to 19. Lordship, may kindly visualize these situations. There are always in every institutions large
ডেট করে যত রাজ্যের ভ্যাকেন্সি আছে রিক্রুটমেন্ট গুলো আসার পরেও আগেও যেগুলো ছিল সেগুলোই গলার ভেতর চলে যাচ্ছে। Yes.
Now, one clarification. Suppose there is total post 10.
Total posts?
10.
10, yes.
So out of which 5 it to be filled up from promotee and 5 is to be from direct.
Absolutely.
Now, present situation it suggests that there is 4 vacancy in the promotee.
Yes.
And there is 2 vacancy in the
direct recruiting. Yes.
So 4 vacancies to be filled up.
Yes.
So 1 from promotee and 3 from direct.
No difficulty as
then when vacancy would be arise, there is easy calculation to 50-54
no.
vacancies.
May I say this? No.
No.
No, there is a ceiling.
From the existing, it is to be ascertained from promotee quota how much vacancy, from direct quota how much vacancy.
May I say this?
Maybe 1 is to
But
3.
whatever quota is a secondary thing. The primary thing is what is the total number in the cadre. If what my learned friends are saying, if that is to be accepted, then for the direct recruitees, the number in the total cadre would be almost, it is much more than 75%. And this rule will have absolutely no basis. Lordship, may kindly visualize this. What was the purpose of the rule to say that 50% to the post? It means that no matter what is the number of vacancies, you cannot go beyond 50%. But if this is to be followed, it will go beyond 50% of the cadre strength.
No, if I say before the promulgation of the rule.
Yes.
There was a quota. You think in this way.
There was statutorily no quota. This is a point for the first time I'm saying.
If anyone says that the post is to be filled up 75% from direct and 25% from promotee.
Yes.
You think that there is a quota.
I take it for the yes.
75% would be filled up from direct and 20% from promotee. It is a quota.
If there is a recruitment process.
Carry forward the vacancy from here, most probably 10 is coming from promotee.
No, may I say?
And 50 is coming from here. Now then you cannot accumulate and say that entire post will be filled up from 50-50.
No, may I say this?
Because the vacancies coming.
I have understood. My answer is in page 40 chart. Total number of supervisor in 2019 is only 1500. No, 15. Kindly see serial number 10. So this 1500 is not all promotees. This 1500 is combined promotees and direct recruitees.
It would be 50-50. It will be subsequently sanctioned.
No.
Post rule sanction post.
But if it is 50-50, then there is no quarrel.
Before that.
Yes.
You are going to take out.
No, I am not.
The post fixed for.
May I say this? May I say this? But I have understood. I have understood Lordship's query.
For clarification.
Of course, no, not at all. May I say this? I say that occurrence of vacancy has to be in the context of a recruitment process. Now, why I am saying so? Otherwise, the substantive rule of 50% ceiling for each category will have no meaning at all. Kindly visualize that before 2015, the government decided not to fill up, let us say, maximum number of vacancies. It's a government choice. Nobody has a right, neither the promotees nor the direct recruitees, to hold it and to carry it forward. Therefore, when the note refers about occurrence of the vacancy, note is trying to take into account the fundamental principle. If the game has started, meaning thereby, if any recruitment process has started before 2015, that means if the occurrence of the vacancy in the context of the recruitment process is before 2015, then that number of vacancies will be 75-25. But we don't have, there is no requirement for us to go there. Because the government in their chart clarified in serial number 9 that the sanctioning of the number of vacancies in 2019 is 4958. So sanctioning is the zero level, I would say, for a recruitment process. So zero level in 2019. So sanctioning itself. Yesterday, meaning thereby before 2019, I decided not to go for a recruitment. So therefore, I did not go ahead. So I sanction, I decide, I as a state, I think I want to go for a recruitment in 2019. Therefore, I sanction. Once I sanction this, that is an occurrence of vacancy post 2019.
No, tell us, Mr. Dhar,
Yes.
whether there had been any quota system, as my brother is saying.
My lord,
in the sense that 50% will be, if I have understood his query,
yes,
it's a 50%, 50%. Today at this juncture, maybe out of 50% in promoting quota, 10 are full.
Yes.
And out of direct quota, 1 is full.
Yes.
So naturally, the persons who are coming
Correct.
will have to, the ratio of the
Has to be
proportion will
applied.
differ.
Agreed. But I think that there is a fundamental logic in that. I would say there is a quota.
Had there been any contention on their part that we are segregating the vacancies 50-50,
Yes.
but as per the status of vacancies,
Yes.
we are filling up 422 and 360.
No. Their logic is this. Well, their logic is very unique. Their logic is this whole cadre was created and there were existence of so they are taking into account all existings of vacancy. Kindly visualize 3009 and all 3009, that's why I said the figure becomes 12.5%. All 3009
are applied to 50-50.
Yes.
75.
They are using, they are banking on the what? Occurrence. They're trying to interpret occurrence is created, but occurrence has to be in the rule, the recruitment rule itself. Otherwise, it has got no value, no relevance.
Yes.
If I say this, my lord, mere existence of vacancy is not the occurrence of vacancy for interpretation of the note. And secondly, the 50% post, that's the ceiling that Lordship is saying. I agree with that. That no matter what happens, the promotees cannot get anything more than 50%. And I'm not asking that because their own figure is 4958 is the total number in 2019 sanctioning. 1500 are already working. So Lordship, kindly make the calculation. So remaining, because 3458, half of 3458 is 1729. All I'm asking this 1729. Now instead of 1729, they are making it how much? 400 and something, which is 12.5%.
Yes, your next point.
Yes, Malad, this is, I just said this. Just a second. 2004 13 SCC 25 paragraph 16 attending. This is on the point. Note cannot control the substantive provisions. Note is to explain a situation. It cannot do something so that whole 50% becomes 12.5%. Paragraph 16. Short. 2004 13 SCC 25. A note to a rule, paragraph 16. A note to a rule cannot derogate from the explicit words of the substantive provision and must be read as explanatory and in harmony with it. If today Mr. Bandyopadhyay's argument is to be taken, harmony from 50% goes to 12.5%. Harmony goes and control goes also. Malad, there is one more judgment. 2005 6 SCC 776. 6. 2005 6 SCC 776. নিজেই তো কপি ইউজ করি না সব প্যারাগ্রাফ 22 23 and 24.
All right.
This is same proposition. All I'm saying, this is the principle, my lord. I'm not required to say that there is not such divergent view. That note is supposed to explain the situation. And I do say that's the reason, my lord. The substantive provision has chosen the word post. So in the whole cadre, number of posts for the direct recruit is basically earmarked 50% of whatever. And that's why note is not using the post. Note is using the number vacancy.
But Mr. Dhod, how you are saying that the total cadre strength is that 4,000? 4,000
Yes.
as on January 2019.
Yes, which was sanctioned for recruitment.
Right. So now there may have been, apart from these posts, there were other filled up posts also.
No. There is no other filled up post. There is no other filled up post. May I so kindly come to chart again?
Page 41.
Yes,
Page 40.
Page 40 itself.
This number of supervisors sanctioned.
I have read it. I spent some time to understand this.
Computation of
this can I use the word jugglery? Then I realized what they have done. Kindly see, my lord, serial number 6.
Yes.
Serial number 6, vacancy of supervisor as in September 2015. Kindly mark, this is a mere vacancy. 3009. All this 3009 for which no recruitment process was initiated.
Where you are getting? Yes.
Serial number 6.
Vacancy of supervisors.
As in September 2015. It's a mere existence of vacancy.
Right.
For which no recruitment process ever initiated before 2015. So what they are doing,
So in 2015, the strength of the cadre was how much?
4958. That is there. They themselves say serial number 4. But there was no sanction to go for the recruitment for the 4958, which was there in 2019 only. In 2015, there were only 1,949 persons working. Same number, because of retirement and other things, came down to 1,500 in 2019. So they are taking the whole pool of the vacancies, which is mere existence of the vacancy, and no recruitment process been taken pre-2015, occurring in the context of. But this is so wrong.
Yes. Next, what do you want?
Yes. Yes. Lordship, I have said, my lord, the post and vacancy. There is a judgment 2020 2 SCC 173, paragraph 35.
2020
2 SCC 173, paragraph 35. Substantive provision is saying post, but the note has said the vacancy. I think that's very correct. But this is basically a 1995 judgment being followed in 2020 also. Paragraph 35.
Yes.
Reiterating the well-settled principle that the percentage of reservation has to be worked out in relation to number of posts which form cadre strength. Thereafter, by the quotation, the expression post and vacancies often used in the executive instructions providing for reservations are rather problematical, like today we are facing. The word post means an appointment, job, office, or employment, a position to which a person is appointed. Vacancy means an unoccupied post of office. That's a vacancy. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. That's a recruitment process. The cadre strength is always measured by the number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect of a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which form the cadre strength. The concept of vacancy has no relevance in operating the percent of reservations. That precisely, my lord, I was saying. The substantive rule says 50% for the direct, 50% for the promotees. That cannot be tinkered with. The note is only to address a situation if there is a recruitment process happened, or in their own language, if there is an occurrence of vacancy pre-15 in the context of a recruitment process, 75-25 can be done. But that is not there here. There is no reason for a note to be applied by your lordships because of 2019 being sanctioned itself.
Yes.
Yes, my lord. My lord, Mr. Bandyopadhyay has, there is one judgment 2023 3 SCC 773, paragraph 85.1, where the judgment relied by Mr. Bandyopadhyay has clearly been overruled.
Which judgment 2023 SCC on?
This is the 2023, it's a larger bench. 3 SCC 773, Rajkumar. This has overruled 83 3 SCC 284, Rangaya. It was 23 3 SCC 773.
No, he has not relied 20.
He has relied. He has relied.
He has given 23 SCC online.
He has also given 83 3 SCC 284.
SCC, yes, 83 3 SCC 280.
Exactly. So 83 3 SCC 284 has been overruled by the judgment I have placed. 85.1 paragraph.
Para
85.1. In fact, this is for academic, because after 2019 sanctioning, nothing is required, but still 85.1, short para. The statement in Rangaya that the vacancies which occurred prior to the amended rules would be governed by the old rules and not by the amended rules does not reflect the correct proposition of law governing services under the Union and the states under Part 14 of the Constitution. It is hereby overruled. So,
but Rangaya was relating to exclusively to promotion, not fresh filling up.
my lord, Mr. Yes, that's why I said this is, I am only showing that
your case is a combined effect.
Yes.
Promotion and
yes. My lord, in fact, if I can summarize.
Yes.
Because I have nothing more to say. I say that the recruitment rule itself is of 2019, sanctioning by their own chart for recruitment. That's the matter. The for recruitment in 2019, as per their own chart, sanctioning in 2019 was 4,958. As per their own chart, 1,500 are already working. So I minus that. So figure becomes 3,458. So this 3,458, my respectful submission, is the occurrence of vacancy for recruitment or in the context of recruitment in 2019. And therefore, half of it promotees are entitled to. And consequently, page 31, instead of giving us half, they have given us 422. So they are giving us, instead of 50%, they are giving us 12.5%. Well, this is wrong. It is incorrect. and learned single judge has directed for a 50-50 on a correct understanding of the rule itself.
What do you say about this? That
But any
central
reasoning can be
government-
supplemented by. But all I'm saying, if the fundamental point is right, lordships can always provide reasoning. I'm not saying whether I succeed or my learned friends succeed. All I submit before lordship is dealing with the situations where large number of persons will ultimately be affected. So there might be a sentence which learned single judge might not happily written it. All I am saying, whatever is the correct position of law, lordship can always tinker with that.
No, what is that central government, Mr.
Yes.
Bandyopadhyay drew our attention?
Well, that is at
36.
36.
Now, please explain to us what is the purpose of this?
Yes, well, in fact, that is correct. That is a very good point in my favor. But since Mr. Bandyopadhyay was more on the point, we have a discretion to make our own rule. No matter what central government has done, we'll go by only after framing the rule. So I made a discount on my submissions. So I did not make any submissions that, look, this 15 is binding on you. In 24, you cannot say. Now, may I say this? Whole object would be diluted if this is not done. Kindly see 15 September 15.
Yes.
May I place it?
Yes.
As you are aware, the Anganwadi workers are the most important functionary at the village level. Under the ICDS scheme, recent years have witnessed not only an exponential increase in the Anganwadi centers, Anganwadi workers, but also significant special efforts aimed at ensuring quality in the delivery of services and community participation. Accordingly, the responsibilities of the Anganwadi worker has increased tremendously, and she is now required to perform multiple tasks ranging from delivery of vital services involving community, women groups, Mohila Mondols, and for ensuring the effective convergence of various sector services. In the broad framework for implementation of restructural ICDS approved by the Cabinet, with the restructuring and strengthening of ICDS, the following provision for rationalization of appointment of Anganwadis as supervisors have been made. 25% post of supervisor reserved for Anganwadis would be filled by the method of induction under the ICDS mission, subject to fulfillment of desired educational qualification and age criteria. An additional provision for filling up 25% of vacant post from Anganwadis based on their merit and track record of service, and additional qualification would also be made. The above position has been reviewed, keeping in view the aspirations of these field functionaries to encourage their participations in the higher post vis-a-vis their merit and to improve their career prospects. The following guidelines on promotions and appointment of Anganwadis to the post of supervisor in supersession of earlier guidelines are conveyed to the states and union territories for compliance. Number 1, the 50% of vacancies in the post of supervisor would be filled up by promotions from amongst Anganwadis with 10 years of experience in Anganwadis and having the prescribed educational qualifications as per the recruitment rules for the post of supervisor, filling which.
So this is in your favor.
Yes. Lordship, kindly look at the object. There are some women who are dealing with some basic need and they are functioning. So we as a government, the cabinet, the central government thought we have to provide them some better hope. So therefore, we make it 50% of the next post supervisor should come from all these persons subject to ABCD, 10 years, some educational qualifications. So that is a kind of hope which is catered so that their continuance of service They are emergency working in different fields at the village level. That is encouraged. Now, today, if it is brought down to 12.5% in this mystical way, this will completely go against this. Learned Single Judge has not gone into the rule part of it so much, but Learned Single Judge has said that 2015, this was 50-50. Today, we are 2024, and the recruitment process initiated in 2009. Sorry.
Come back to page 31. Where is this memo of 22nd February 2019? Second line.
Yes, well, I'm coming. Second line, VDA UA number dated 22nd to 19.
That is not there, no?
This is, well, may I just check? This is.
You have 25th February.
Correct.
Not the 22nd one.
Yes. So it seems recruitment rule, then cabinet decision, this total number of vacancies. So that's, in Lordship's language, that's some kind of initiation for the or in the context of recruitment. That's the beginning. If that is the beginning, my lord, that is the end of the matter.
Where is the, what did you say?
I said that I am directed to inform you that 55th meeting of cabinet held on 21st February 2019 has approved VDA its EO number such and such dated 22 to 19. Roman 1, recruitment rule for the post of supervisor under ICDS. Roman 2, filling up of vacancies of 3376 posts. I am on this. Roman 2 is a decision taken by the cabinet in 2019
to fill up 337.
Yes,
that has to be 50-50.
Yes.
Yes.
Well, I have nothing to say. Deeply appreciate.
May I have a very short submission, my lord.
Before going into
My lord, I have a very short submission, my lord, in respect of
who does not.
Pardon, what you are saying?
Saying that page 31.
You tell us you are for whom?
I have 493 mat number, the writ petitioner in the trial court, in the court below.
Writ petitioner in 493.
Yes, my lord. MAT number 493.
1, 2, 3. That is, you are at par with Mr.
Yes, my lord. But some points I am just pointing out before Lordship, my lord. That is page 31, my lord. The vacancy notification is 3376.
Page 31.
The vacancy was declared 3376. But when we challenge this matter before the trial by a single bench, my lord, then the single bench sought for report. In the report, my lord, that is page 40.
Yes.
There is anomaly of vacancy, my lord. Here we found that the serial number 11, the 3458.
Yes.
The vacancy are not tally with the advertisement, my lord.
That is 3476.
Yes, my lord. 3376.
3376.
3376.
We are not
number is
required
not
to
telling,
go
my lord.
into the nitty-gritties. We are to decide whether percentage will be 50-50 or 75-25.
Yes, my lord. That will survive. But my lord, one.
No, how does that help you? If the figures do not tell you, how does that help you?
But there is anomaly in the recruitment process. That's why.
This report does not tally with the
vacancies
as stated in page 31. Maybe. 31. Yes, anything else, Mr.
And one irregularity, page 40 in para 1.
Page 40, para 1.
Yes, para 1.
Yes, what do you say?
Serial number 1, my lord.
Serial number 1.
But there are, my lord, A, B, C, D, E, F, G, H heads.
Yes.
But in paragraph 1, my lord, it is found from their report, my lord, they have already given 50% prior to 15, my lord. So there is total anomaly.
What?
In serial number 1, my lord.
Yes.
Well, they have already 1500 vacancy was there in C.
Where do you find 15,000?
Para 1 and 2. Next 2, my lord. So one is September.
Two is for
January
50-50
19.
ratio.
January 1950. 1500. And before that, my lord, just above
100 for supervisor.
just above, my lord, September 15. 1949.
Yes.
There was also, my lord, the D and E, my lord. There was ratio 50-50. D and E, my lord. Can you see the D and E?
Direct selected 964.
964, and my lord, the promotion is 984.
Yes.
85.
That is 50-50.
There was 50-50 before 2015.
No, what should be, what they are saying. Up to September 25, total number of supervisor 1949.
Yes.
And existed directly, out of which directly was recruited was 964. And promotion from 985. But it should be
25.
75.
25. Yes, sir.
So 75-25 should have been 1468 and 487. But in reality, there was a promotee of 985. That means excess in promotee quota. Hence, I am using the word quota, though legislature has not. Here, 494. Similarly, in January, 16% in excess in promotee quota was recruited. That means previously there was 514 promotee candidate was appointed in excess.
In excess.
Now they are to be adjusted.
Just one. The concept of excess will only come when it goes beyond 50% of the cadre strength. That's the substantive provision. So whole excess is their imaginary excess. Excess will be when I go beyond 50%. Otherwise, no concept. This is an absolutely wrong excess they are understanding. Kindly think over this.
This calculation of excess itself is discrepant.
Absolutely, yes. Yes. Exactly.
My lord, I have a very short submission, my lord. I am appearing for can 6 and 7. My lord, I am appearing for can 6 and 7, my lord.
The magic here.
যেটা বলছে যে ওই এক্সেসটাকে আমরা অফিসের সাথে অ্যাডজাস্ট করিয়ে এই রেশিওতে আনছি
ঠিক আছে তারাও না
My lord, I can 6 and 7.
And I adopted Mr. Dhorsa's submission.
No, this 498 and 16 as per the chart was in excess. The 498 in promotion quota was in excess prior to the cutout date. So, Mr. Bandyopadhyay, how you are explaining that this 498 you are
excess in the promotee pool.
very good. Now, how you are adjusting that with this present?
Yes. Your lordship will kindly take that at serial number 7. Serial number 7.
Yes.
Can I take serial number 7? Once we apply 7, we get, it should be application of 75/25 will take us to 752 in serial number 6 Roman 2. Your lordship will find 752.
Yes.
In the next row, that is serial number 7, actually to be selected from promotion 752 minus 498. That excess 498 is being adjusted here.
The vacancy.
Where is this reflection in your memo?
Reflection.
Where is this adjustment of?
Memo,
we will go to
this working out.
No, we will go to that. Your explanation is that there was an excess in promotion. So if there was an excess in promotion, this ought to have been considered by the cabinet. So if cabinet after consideration, how it is saying that 3376 will be for
total 2954.
Total 2954 will be for direct and
420 for promotee.
How you are reading?
Exact figure in that notes. Kindly take note, page 31.
Page 31 is 7th March.
That is impugned. That is the only impugned memo. Kindly take 422 number of posts will be filled up fourth line.
Yes.
422 will be filled up by promotion.
Huh.
And sixth line, the remaining 2954 will be by direct recruitment. This is that figure being matched. At
How you,
20 and 20.
no, how this doc,
Serial number
this,
20
this
and 20.
segregation then does not
Matlab,
tally
they
with 70. Please, I'm questioning this. These 422 2954 figures are in tandem with 3376 total vacancies. So if you say that adjusting the excess promotion, we have come to this figure that disturbs your own ratio.
But it won't.
Why? Because it
After
comes to
application of this-
12.5 is to 87.5.
That's one of the roundabout one of the calculation which is being done today.
So you are allowing them to make such
You
calculations.
page 40. Malad, you will kindly appreciate this.
Yes.
Page 40, kindly take serial number 20 and 21. 20 and 21. 20 is 2954. 21 is 422. After this 23 lines of calculation, we come to these two figures. And
Now,
this figure
why
is
you are
approved by the cabinet?
just why you are subtracting 41 from both of them?
Because in the meantime, 41 in Jungle Mahal was given for direct, 41 was given in Jungle Mahal for promotion. This 41 plus 41, 82 has been deducted. That is also there in serial number 16 and 17. So we have not hidden anything. Malad, strong adjectives may be used against this calculation. I am appalled to see this. It is strange. Wrong has been done by the state. But we have laid our hand very clearly at how we have calculated. At serial number 20 and 21, the figures are there, which is reflected in the impugned memo.
No,
Your
very
lordship
good, very good. That then the state also is logically arriving at this. Na? State is saying 2954 is for promotion and 422 is for direct. Now this calculation you are coming after adjusting the previously existing vacancies.
As on the date of the cutoff. As of the date of the cutoff.
Cutoff on 15 September 2015, there must have been some maybe excess or deficiency in the quota respective quota.
Either of the two.
Then on the basis of which provision are you adjusting this?
As on that date, the requirement was that the ratio should be 75 to 25.
Right, understood.
And in the next regime,
it will be 50-50.
We have gone by that, Madam.
How?
It is not.
Show us one document which allows you to do so.
Your lordship will kindly see this.
Now, please answer our question. Then we will hear your argument. We are wanting to know from you, as you have rightly pointed out, that you cannot just take up the vacancy suddenly one fine morning. On the date you are calculating, you have to take into effect, according to you, the number in excess and the number in deficit.
Yes.
Which provision permits you to do that? That you can adjust the excess and deficiency existing as on prior to 15 September with the vacancies which you are going to fill up in the new
Prior to 15 September, the requirement was 75 to 25. That's the admitted case of all parties.
Right. But there was an excess.
There was an excess.
Right.
Which is at the time of recruitment, my lord, this calculation is being done to bring it within that ratio.
Then there must be a line to that effect in your cabinet decision, as you are subtracting the Jungle Mahal. Jungle Mahal you are subtracting, for that reason everybody we are accepting.
May I kindly say this? What is their approval in the cabinet memo is 2954 and 422.
Right.
Now this 2954 and 422 are not figures we are plucking out of thin air. This 2954 and 422 is a deduction from serial number 1 to serial number 19. If serial number 1 to serial number 19 at page 40 will not have been there, then we will not come to serial number 20 and 21 this calculation. Therefore, when
that is your argument, Mr. Bandyopadhyay. Please satisfy us on this issue that this adjustment is reflected from the records. You are coming up with a chart in answer to the court's query.
Spend a few more minutes on this chart.
Certainly, sir. We want to listen to that.
May I make one humble submission? My lord, can 7 and 8, only 2 minutes, my lord, I will take of your lordships. Can 7 and 8, I am a direct recruitment, my lord.
Addition of party which I am opposing.
Addition of party.
Two applications for addition of party your lordship has kept for the final hearing, which I am opposing, my lord. Because their cause of action is not with regard to the ratio.
Hold prayer, my lord. If your lordship holds that it should be 75 and 25, then my lord, I am getting an appointment. Even if it is 50-50, I am getting an appointment. Only difficulty is that they are following 50-50 pursuant to order passed by the single judge. And they have appointed person below me. I have prepared a chart. Only thing, whatever your lordship holds, it should be according to merit so that nobody, whoever in the panel is not left out. This is my only limited prayer before your lordship.
This is not the subject matter.
As a 1 minute, total post is 4958.
Yes.
Total.
Yes, my lord.
Now, before
Half.
2005, how many vacancy arrows?
3009.
Before,
2009.
no, before 2000.
That is serial number 6.
2000, before 2015, it was also 4958.
Post, not vacancy.
Post.
As you have entered.
Yes, correct, correct.
4958. I agree with my lord.
No, I'm saying,
Vacancy,
correct.
you have stated.
Before,
Post may be 100.
correct.
Out of which 10 is vacant.
4958.
90 feet.
No, vacancy was 3000.
Post.
No.
Post
is 4958.
So total post.
Yes.
4958.
Half is
Out of
2479.
which vacancy arrows before 2015 3009.
Not vacancy arrows. Vacancy merely existed because of no recruitment. These two things are different.
No recruitment.
Vacancy arrows has to, lordship, getting the what from a recruitment rule.
Exist.
Yes. Yes. Mere existed of 3009. 3009.
3009.
Right.
Acha. After that cutoff date,
Yes.
how many vacancy were there?
It
449.
is.
449.
This is
349 serial number 12.
No.
If I'm wrong.
My lord, in 2019, total number, kindly take serial number 9, 10, and 11. Yes.
449. Serial number 12.
Just a second, let me see.
3458 minus 3000.
Serial number 12, 1 or 2?
12. Only 12. Plain 12.
Okay, plain 12.
Vacancy of supervisor.
Vacancy of supervisor between 15, correct.
Yes.
Right, 449.
449.
Yes.
So now they are claiming the out of
No,
449.
what is the next column? Out of which to be
50-50 is applied.
50-50.
449 we are dividing into 224 and 225.
That would be, my lord, disastrous to the rule.
Let us let us
Because why? Half of all I say, the half of 4958 is 2479.
75.
They have a complete freedom to do anything within 2479. Half of 4958 is 2479. I do not say to them they can do anything with 2479. But the moment they want to cross 2479, they will hit the rule itself. Because then it will be exceeding 50% of.
If they start a separate selection process,
Yes.
in respect of 3090,
They did not.
getting that it would be
Had they started so, things would have been different. But they did not. They did not. And there the lordship's judgment comes.
If you added, the promotee will get benefit.
No, promotee will not. Kindly see, promotee will not get the benefit because promotees have to be satisfied with half of 4958. Therefore, no matter what happens, the promotee cannot go beyond 2479.
No. That defeats his argument. That defeats my learning.
Yes, kindly calculate.
495 is total. That means there are existing and vacant. 4958 is posts. So there are existing persons. If we restrict it to 50-50, then the existing persons, if there is an excess, they will have to be thrown out of the service.
Existing is only 1500.
Our next friend's argument is that they have to be adjusted. He is making the same argument in a different bottle.
We are not on that, Mr. Bandyopadhyay. You explain us this adjustment is pursuant to the rules. Show us that.
My lord, yes. My lord,
This adjustment is in consonance with this memo. Only show us that we dismiss you, we allow your appeal, we set aside the order.
my lord, prior to September 2015, the ratio to be applied is 75:25. That is an admitted case of all parties.
Yes.
So, my lord, as on September 2015, the total number of supervisors were 1949. I am at serial number 1. And there is a 964 direct recruitees and 985 promotees as supervisors. But as on that day, what was required was 75:25. The next two columns are what it should be. Kindly take the heading, what it should be. It should be 1462:487.
অনেকটা বেনিফিট এটা যদি আমাকে 70 বা এরা 2500 দাঁড়াবে না 2700
না না 15-তে এক্সট্রা এক্সেস ছিল 98
No, no,
সেম ক্যাবিনেটের কোনো কপি টাচ করা যাবে না ক্যালকুলেশনটা থেকে এই না জায়গাতে এসেছে
এটা একটু নোট
ভ্যাকেন্সি এটা হবে
রিক্রুটমেন্ট নোটিফিকেশন তো হচ্ছে রিক্রুটমেন্ট সিলেকশন
এখন অলরেডি তো করে ফেলেছে মোদি অলরেডি তো
চাকরি চলে গেছে চাকরি করছে কোথায় চাকরি তো বলেছে যে তুমি 50-50 তে করো হ্যাঁ 50-50
if your lordship kindly takes page 40, what I am trying to submit is that what is impugned before your lordship is page 31, which is the memo of 7th of March 2019, which gives a figure of 422 and 2954. This 422 and 2954 is a result of some deduction. The result of some deduction. That deduction, upon being called for by the Honorable Court, we have given in the additional affidavit, that is page 40. That is page 40. Your lordship will find that calculation at serial number 20 and 21. Now, my lord, your lordships will find at serial number 6.
Now, just one question. When you are making this 7th March 2019, you are not prescribing the ratio in the preamble. You are saying, no, we are filling up 343376, out of which 422 and 2954. This is supporting which ratio?
But this is supporting the ratio as applied at page 40. And why I say that, my lord will kindly, with the deepest of respect, my lord, will kindly not expect that memo of 7th of March
to contain the entire calculation in the first paragraph. The final figures have been given. The calculation is there in our record, in our files, which we have reproduced in page 40. It is not that we have arrived at that figure without any calculation or any deduction. It is not that we have arrived at that figure without applying 75:25 or 50:50 at the relevant point of time. What has fallen for decision is that whether our application of a cutoff date was right or wrong. Whether we applied this cutoff rightly or wrongly, thereby applying 75:25 to 3009 vacancies, which occurred prior to 15 September 2015, and applied 50:50 to the remaining vacancies, which occurred after 15th of September 2015. This is what has fallen for consideration before Lordship. Now, my lord, this calculation of 2954 and how it has been applied, my lord, with the deepest of respect, my lord, that was not challenged. Now, this I agree, my lord, 7th of March 2019 does not contain the calculation in the memo itself. But what I'm trying to say is that the figures which 7th of March 2019 contain is out of a calculation which is there in our file. It is not something utopian or we have come up
40.
with.
That is
Page 40.
Yes.
That is page 40. Now your lordship will find a figure in page 40 at serial number 11. That is 3458. Serial number 11, 3458.
Yes.
At serial number 11. This is the number, this is vacancy of supervisors as in January 2019.
Including
prior to September 2015 and post September 2015. To this, the Honorable Single Judge has applied 50-50 ratio as a whole, without seeing what has gone in jungle mole, what is covered, what is not covered, who is existing in the post, who is not existing in the post. Nothing has been considered. But assuming our calculation is wrong, my lord, going by that, we'll have to throw everyone out in the jungle mall recruitment which has happened, which is mentioned in serial number 16 and 17, and do it afresh.
No, we are not touching that. We are on
application of the ratio. Malad, this application of the ratio is at 6, serial number 6, Roman 1.
It was the 3458 was the vacancy you had considered.
Yes.
So 3458.
The bifurcation is 3009.
Now where does this figure 3376 come?
3376, my lord, is addition of 2954 and 422. That is serial number 20 and 21.
Achha.
That is the same figure mentioned in the impugned memo. But in the advertisement, your lordship will only find the figure 2954, because for promotees, that advertisement was not applicable. It was separately the 2954.
So you are saying that as per your calculation, you have taken into consideration the excess and deficiency in the respective parts. And you have come to the conclusion that 3376 is the vacancy. 3376 is the vacancy for which you have applied what ratio?
Yes. Well, 2 serial numbers. Kindly take 6 Roman 1.
No,
and
if we
12
go by
Roman
your
1.
argument, then 3376 you will be filling up by 50:50.
No.
Why?
Because of serial number 6, kindly take serial number. This 3376 has 2 parts. One is 3009. That is prior to September 2015. 3009 vacancies occurred prior to September 2015, and 449 vacancies occurred after September 2015. These relevant serial numbers are serial number 6 and serial number 12. Serial numbers plain 6, not Roman, numerical 6 and numerical 12.
So there were 3009 vacancies prior to
September 2015
and 449 after.
Now
total comes to?
Total will come to 3458.
3458.
From this 82 is to be deducted, but deduction comes later. Next step is 6 Roman 1 and 12 Roman 1. But these two serial numbers are extremely important. Kindly takes it for my satisfaction once. In 6 Roman 1, we apply 75:25 to 3009 vacancies. This is where my learned seniors are joining the issue that you could not have done that because the recruitment process was not prior to 15 September 2015. Serial number 1 and serial number 12 Roman 1, 12 Roman 1, where we have applied 50-50 to 449 vacancies. Question is whether in law we have done this rightly or not, whether we were right in bifurcating it or we should have applied it 50-50 to the entire vacancy available to us in January 2019. To that, irrespective of Rangaya being overruled, my answer is that there is no straitjacket law which will force the state to apply the law as on the date of the law, on the date of recruitment. And that judgment that Mr. Dhar had cited, when it was pointed out by your lordship when I was making my submission that it has been overruled, I went home and did my own homework, If your lordship kindly takes that judgment once, that 2023 3 SCC 773.
So why were you not cautious in framing the rule? These occasions could have been washed away.
There has been no infringement. My learned friends know that. My learned friends sat on the fence, waited for these matters to be concluded. They did not come before the writ court challenging it, Kindly remember this. They are before the appeal court for the first time. Only my learned Mr. Banerjee's client was there before the writ court. Mr. Dhar's client was not there. They did not challenge the rule. They did not challenge the note. Today, these submissions are being made. They have not come up with
they were not parties to the process.
No, they came by way of addition of party in the mandamus appeal. They have not challenged the rules. They have not challenged the advertisement. But I'm trying to repeatedly make this submission that the rule, the note, irrespective of bunch of decisions being shown, the rule and the note is not under challenge. Interpretation of the rule and the note is not under challenge. Whether note will override the substantive provision or substantive provision will override the note, that is not the subject matter of the litigation. These are distributaries supported by hefty adjectives. Now, kindly in that 2023, kindly takes paragraphs 82.5 and 85.
Prerogative of the council. Hefty.
But I am not being able to match them. Kindly takes in the 2023 3 SCC, that is Rajkumar, and there are at least 8 to 10 other decisions which I don't want to show in reply, but my point is very clearly made out in 82.5 and 85. Kindly takes that. And that is why other decisions are not being shown, because the golden thread is this. There is no bar on the state.
Yes.
82.5.
Yes.
When there is no statutory duty cast upon the state to consider appointment to vacancies that existed prior to amendment, the state cannot be directed to consider the same. Therefore, there is no bar on the state. No mandamus can be issued on the state that you go by this, but there is no bar on the state to apply that law. Also, kindly takes 85. Just prior to 85.1, which was placed by Mr. Dhar, kindly takes 85. The consistent findings in these 15 decisions that Rangaya case must be seen in the context of its own fact, coupled with the declaration that there is no rule of universal application to the effect that vacancies must necessarily be filled on the basis of the rules which existed on the date which they arose. Therefore, it is up to the state to make this decision that which law to apply to the recruitment. But no mandamus can be issued upon the state that you only apply the law which is existing today. This administrative choice has to be left to the state.
That cannot be said to be false within the discretion, sole discretion of the state. State is duty bound to follow the statutory rule.
Yes, but for that,
state is there not to confuse the
Actually,
litigants.
we want to another clarification from Mr. Dhar. Mr. Dhar, as and when the legislature declared that the total post, 50% of the total post will be filled up direct and 50% will be filled up by promoting.
Right.
The legislature intended
that
to create a quota system and to
correct
a reserve.
Yes, I cannot go beyond that. Exactly.
That means 50% you consider the first institution.
Exactly. But they will go beyond 50%.
50% of the total post.
Yes.
I am not using
Correct.
the word
Total post.
vacancy.
Correct. Correct.
Post will
Yes.
be reserved for the promotee, 50% will be direct.
Correct. Correct.
Now vacancy occurs
Yes.
due to death of the employee.
True. True.
eh?
True.
Due to transfer,
Correct.
due to anyone has left the job.
Correct. Correct.
Then vacancy was 10.
Yes.
And 10 occur, again I am saying, 5 from 6 from promotee
Yes.
and 4 from direct.
But it cannot exceed 50% of the post.
Cannot claim, as and when vacancy will arise, it used to be filled up 50-50.
No, but ceiling is 50. If what state is going to do is to be accepted, then it will go beyond 50 for the direct recruitees.
No.
Yes, it will.
I am giving just this calculation to you. 3,000 total vacancy.
Yes.
And next vacancy.
Finally, first take the total cadre. 4958 is the total cadre. Serial number 9.
You forget about the same.
Okay.
Total vacancy is yes. Okay. Total cadre.
Yes.
Total
So now
cadre,
first.
4958.
Yes. Now
out of which
2479 is the ceiling.
2479.
So no one can cross 2479.
2479.
Right.
Okay, let us see.
Yes, whether they have
Now-
crossed or we are crossing.
Now,
Kindly see, we have not crossed it.
yeah, 3009.
No, ours is only 766 as on date.
Now they are claiming that 3009
Yes.
is to be filled up by 75-25 days.
Yes.
That means he will get approximately 750 and odds.
Yes.
3000 and
Yes.
750 and odds.
Still within 2479.
So I am for sake of argument, I am 750.
Yes.
And 50-50 from 449.
Yes.
That is 200 year, 220.
No, that 75-25.
That means-
No, one thing. That 75-25 lordships cannot take unless lordship holds that there was a situations when recruitment process occurred.
Allow me.
Yes, sorry,
it's also
sorry.
my thinking process.
Yes, yes, my lord, that is the beauty of.
Now that would be 994.
Yes.
You will get 994 according to them.
Yes.
994. And if the existing
Yes.
is calculated, then what would be?
Kindly take existing is 766 promotees. 766.
766.
Yes. That is their figure.
As enumerated in 2, serial 2.
What number serial?
Serial 2. 2E.
Yes, kindly see. Serial number 2.
2E. Yes. 2E.
2E. Yes.
Number?
Yeah, correct. 2E. 766.
E.
Yes, 766 is existing promotees. Now my ceiling, kindly take my ceiling if I consider 50% of the cadre. 50% of the cadre means 2479.
Now you want.
I want 2479 minus 766.
Okay. And
That's why I said it is.
Total, how much total?
The total to the point is
All I said that I can go up to 2479. I am not asking beyond that.
Now 50-50 direction is giving. That
Yes.
More post from promote you will be filled up.
495.
You calculate.
Lordship, kindly see. Two things. Lordship is saying that it should be 50-50. I am also saying that. Then what is the...
The post, not vacancy.
Yes, I'm saying post. Vacancy is the lesser thing. 50-50 of the post. Now 50-50 of the post, if it is to be translated for the understanding really, what does it mean? It means 2479. 2479, I cannot exceed. 2479, they cannot exceed. Now today what we have? 766. So I say that give 2479 minus 766, give me that, because that comes under the rule.
Minus 41.
But what they want to do is, they take the whole existing vacancy without any recruitment process being initiated. So it becomes 12.5%.
Without interrupting my learned senior, my lord, if this is put down in writing, and
Yes, I
seen
can-
with the impugned order, your lordship will again feel that going by that calculation also the impugned decision is wrong. Wrong in law.
Impugned decision, if there is an incorrectness, lordships are there to correct it. But the point is there has to be correct answer of law.
May give reasons if the reasons are not adequate, but if the conclusion is right. But if the conclusion is wrong, then the entire order changes.
But this is not a technical. Ultimately, can we
Going
give?
by Mr. Dhaw's own argument that impugned order
Can
is
we
wrong.
give a short note? Can we give a just short?
Not
Alright.
required.
But deeply agree.
But that is the can application I am opposing, my lord. Before going,
Yes.
Before that, your lordship's question was, tell me if your lordships need any verification after the submission, then your lordship will call them.
Presumption হবে good.
এরকম করে যদি আপনার পার্সেন্ট হয়ে যায় তাহলে তো ইয়ে হয়ে যেমন ভ্যাকেন্সি যখন ডিক্লেয়ার করা হয় তখন প্রমোটিভ
সেটা তো আমরা বানাচ্ছি, এটা তো মেমোতে বলে।
কোন তো পোস্ট করেছে ভ্যাকেন্সি
না না,
মেমোটা দেখুন পোস্ট এইখানে ভ্যাকেন্সি মানে পোস্টটা যত যত এখান থেকে 50 এখানে 200টা, কিন্তু এদের জায়গা থেকে ভর্তি করতে হবে 50টা। এইভাবে যদি যেতে হয় তখন দেখা যাবে একজনকার বেশি হচ্ছে, একজনকার কম দেখছি। এইটা existing vacancy is to মানে vacancy is to be 100% rate যদি না ইয়ে হয় তাহলে কিন্তু পরবর্তী ক্ষেত্রে সেগুলো কিন্তু অ্যাডজাস্ট করে। এখন যদি সেটা 50-50 বেশি একটু ভর্তি করলে যদি না কারণ বেশি
That point. What lordship is thinking, I have already calculated. Far less.
If now direction is given, you fill up 50-50.
Yes, we are happy.
Whether you will and in addition to the existing post,
Yes.
whether you will exceed the
It will not.
post,
It will not exceed 7. I said
number.
nothing is it. A number is 766. Cut 766 from the 50% of it. Give it to that. But it should never be only 400.
And now total post is 3376.
No. Total post is
4958.
4958.
Vacancy
no,
376.
Post, sorry, vacancy. Total vacancy.
No, lordship. No, lordship.
Half of that.
345.
No.
Half of that.
No, first lordship has to.
1688.
Yes.
Plus 7 such and such.
plus 766.
Is still not reaching that target of
Vacancies
not reaching 2479.
মানে টোটাল কাডার স্ট্রেংথের পোস্টটা নিয়ে নিয়ে ওটা কি 70
করে দিচ্ছে।
চিন্তা
এরাও একটু বলবে
yes
Many things has been said about numbers. I think not this case should not concern your lordship the numbers because of this rule. Kindly come to page 51, that's the rule. The rule is not under challenge.
You are not required to challenge law.
Any commentary corona. Yes. 51.
So this is not under challenge. It's a rule made under provision to Article 309. And Mr. Dhor cited a case saying note cannot really disrupt the entire body of the scheme. Kindly say note. It refers to the body of the scheme. This is not a one-time exercise, this rule. This rule has come to stay. But at the present moment, there is a departure from this. That is why note specifically mentioned that up to vacancies 30th September 2015, one way and otherwise. So it's not a one-time exercise. Note is a one-time exercise. Therefore, note cannot destroy the main point. After 2 years, when promotions are given, recruitments are made, 50-50 will be there. 50-50 has come to stay. But the point is, when the rules under 309, they specify, after taking into consideration, in case of vacancies of the ratio, direct recruitment indicated in Rule 3A. Therefore, Rule 3A has been taken note of. And recruitment from category of Anganwadi worker, as indicated in 3B, that is also taken note of.
They ought to have stated selection. Problem would have ended. Instead of recruitment, they ought to have stated selection.
Lord, may I tell you one thing?
And you also know that, Mr. Secretary.
Lord, I know nothing of law. Therefore, Lord, kindly do not, kindly see. We have said, in case of vacancies such and such, the ratio of direct recruitments
Directly.
as indicated. Question is, why this recruitment term has been issued? And
Recruitment includes selection.
Recruitment is the starting point.
No, recruitment is not the starting point. Advertisement is the starting point.
No.
Recruitment is on much earlier.
May I subject to correction by your lordships? As I understand, recruitment is a process that starts for the purpose of selection.
No, instead of going into that, you may say that this is not under challenge by.
That's right. That's what
so
I
we
say.
need not dwell on that. Very good. Yes.
After this, nothing remains in the writ petition.
All right, Mr. Secretary. Yes, Mr. Banerjee, what you have to say?
I have two applications, CAN 6 and CAN 7, in Appeal 509.
CAN 6 and CAN 7.
For addition of parties.
With Mr.
Mr. Dhors is appearing for the directives. Mr. Shudipta Dasgupta. Mr. Shudipta Dasgupta, he is appearing with. Yes.
With you?
Yes.
Oh, you have filed these two applications in MAT?
I promoted.
You have filed in MAT?
509.
509.
Yes.
Achha. Yes, who are you?
Directly. I am caught in the crossfire. I tell you, Lordship, why? Be it 75-25, be it 50-50, we are so meritorious that we have to be given appointment, irrespective of the ratio of which the government wants to go with. But because of this crossfire, our appointments are held. We only say this, let this dispute be adjudicated upon, but that should not be an impediment for our appointment.
Why you have the coordinate bench has said fill up this much?
That is not happening because of this litigation.
It will happen soon.
Yes, my lord will kindly make a time frame.
Your inclusion will not ask us to deliver the judgment tomorrow.
But kindly take care of us also, so that we get our recruitment, our appointment.
Dispose of, sir, what is your problem? You will come.
They are opposing that addition of party. Their cause of action has nothing to do with the ratio.
That we have heard, you have said so.
Yes, paragraph 4 of both the applications is their case.
Yes.
They are at a stage of reservation subsequently your lordship deciding this matter, that what should be the number of vacancies either there, direct or promoted. They say that in the next stage, reservation policy has not been made. Paragraph 4 in both the application.
We had
Sir,
heard
I'm
that.
sorry, my lord. Paragraph 4 in Can 6 and paragraph 8 in Can 7.
No, his anxiety is
I'm not getting into
that
these
we
things
are-
at all.
that
We
due
are
to
not
this.
following the reservation.
No,
And
you are
this
not.
roster should be maintained. Well, that's what we
Coordinate
say.
bench judgment has not been followed. You have given appointment.
Their point is in
No,
Can
no.
6,
Has that order been complied with anybody?
50%.
50%.
50%. But my lord, that is not their point.
No, up to 50% added. Appointed.
1529 out of 1729. 15%.
1729.
Well, that has happened without following the roster. There lies a
Let us understand.
1529 has been executed without prejudice to exercise rights and contentions and in terms of the interim order in this appeal.
From direct equity or?
Directly.
Yes.
From direct as well as promotion.
From direct.
From direct.
Achha.
From direct. Direct.
And promotee is 401.
Promotee is 401.
Both are under either of the threshold. But Mr. Banerjee's point is that in
401 promote is given.
Yes, 401.
Yes. So coordinate bench order complied with.
To that extent, no. May I put it in this way? Interim order in this appeal complied with.
Yes, that is what.
In this appeal. But Mr. Banerjee's point is that in this figure that your lordship noted, Mullah.
Mr. Banerjee is in which card? Direct.
Yeah, direct. He is saying that we have not given appropriate reservation to OBCA, and in Can 7 he is saying not appropriate reservation to
the 100-point roster has.
You have not yet, but 1529 has been appointed.
I have not yet been.
1529 appointed.
Yes.
You are not coming within that.
Yes.
That due to the mistakes in roster.
Yes.
100-point roster. That is
And
the
Miller,
subject matter of
yes,
the
and Miller, that has culminated because of this dispute, this thief
This
only.
is a civil post. They have to go
This
before the
thief only.
tribunal. They must approach the tribunal.
Miller, state is, Miller, after all, not a quarreling, Miller, a quarreling litigant.
State may be there before the Honorable Supreme Court also. That does not mean that all the forums have to be let gone and they have to apply before that forum.
But I wonder how can Miller state even
that
oppose this
discussion
prayer?
to ask Mr. Bandyopadhyay whether we will entertain. Yes.
So, Miller, we say that, Miller, we may be given appointment following the roster, Miller, be it 75, 25, 50, 50 at time frame, and Miller appointment in terms of the roster. That.
All right. The learned advocate appearing.
In division bench order not to cross 1729, but they have filled up only 409. They have complied the order, that is wrong. The division bench order said not to cross the 1729.
401 is
but 409 only fill up from the promoter.
Yes. Otherwise,
this is clarification. But he has
that is
saying
jeopardized.
the single bench order complied.
776.
Once the division bench was pleased to direct not to cross 1729, but only fill up 409 from the promotee. Not fill up 1729. My learned friend is
No, 1529 has been appointed from direct.
that is what they are saying. They have complied the single bench order. That is wrong. Division bench also saying the order by directing not to fill up one.
Very good. That issue becomes that is a incidental issue.
But
when we are deciding the matter,
yes,
you will get the result from the judgment.
Compliant.
He says he complied. You say you not.
No, my learned friend has not heard me. I have said I have complied with the interim order in the appeal, not with the.
No, one thing. After filing the writ petition, they choose to file a appeal. This is the wrong right. Several writ petition is pending. These for implementation of the single bench order. After that, they have filed that.
Implementation of the
order of the largest single bench.
Yes.
But after that, they filed the appeal, and appeal court, they have directed not to cross.
I don't understand you, sir. The writ petition disposed of. Against that, they have come up in appeal.
May I clarify? There is a good number of promotees. Now, some of them initially came, they were successful. Now, when they became successful, what happens that out of the promotees also, my lord, certain criteria have to be fulfilled, like 10 years service, and they are successful in the examination. Now, who are the writ petitioners? Some of them might not have fulfilled all. So maybe they had a little vigor in continuing with the appeal. So other promotees came, filed an applications, and all were added. They stepped into the shoes of the writ petitioner itself. So thereafter, since the number of the promotees are more, and since the single judge's order was not complied with, several writ petitions also filed so that this 50-50 is followed, complied
So
with.
many writ petitions
Yes,
still
once
pending?
lordship decides, so it will govern that. That's why I said that once the fundamental point is decided, everything is decided.
বুঝতে পেরেছেন কোথায় গেল কাজটি? ইন্ট্রিম অর্ডার
ইন্ট্রিম অর্ডারটা কত তারিখে গো? ইন্ট্রিম অর্ডারটা কত তারিখে ছিল?
না না, যেটি রিচিং অর্ডার পাস
Please, 11th July.
জেরক্স করে দুজনকে দুটো দিয়ে দিন, জেরক্স করে কতক্ষণ লাগবে? আমরা ঠিক আছে, তাহলে দুটো এখানে
Interim order was of 11th July.
হ্যাঁ 11 জুলাই বার করে এখানে একটা আর ওখানে একটা দিয়ে দিন। আর হ্যাঁ
Interim order followed, my lord, 1729 for both. That you can go up to 1729 for promotees, for direct recruitees. That was the interim order. Because that's also 50.
We did not go to that extent because our notification was 422. So we did not exceed 422. We did not want to get into that situation where we had to remove them.
My lord, before taking decision, my lord, kindly, since it is a government appeal, state government appeal, kindly page 49.
What you are
Page
saying?
49, because my lord, it should be clarified, my lord, because my lord, kindly see the date and the
Arey, how many? Don't argue by
kindly
installments, sir.
see the page 49 once, my lord. Kindly see page 49 of their appeal.
So why didn't you say when you were arguing?
49 কি আছে?
509টা।
কি এটা?
মেমোটা দিচ্ছ কেন? আর এটা ইনিশিয়াল মেমো তাহলে কি করে হাউ দ্য রিলেভেন্স অফ দিস লেটার?
Mailman has approved.
Page
49.
40?
49. The date is given 20th December 2018. But decision is first line. I am directed to inform you the 55th meeting cabinet held on 21st February. 19.
I think it's a typo. I think it's a typo.
typographical mistake.
I think
My learned friends defense in the appeal turns on that, I have nothing to say.
It is your appeal. It's
Yes,
no. That must be type. It's
if you
nothing.
can get the appeal dismissed because of that, I have nothing to say.
What
Well,
you
let
are
us
saying, sir?
concentrate on
What you are saying, Page?
the point কি আপনার?
At a point about it is also a part of the anomaly.
What is the wrong in this?
The date is wrong.
The date,
Wait now.
it is the wrong one. The memo is the correct, different.
What should
memo is
be the
different.
date? What should be
So,
the?
since they are the appellant, say they should clarify it. What is the why it has been written?
এটা কোনো point না, ছাড়ুন না. There are fundamental. Well, lordship is concerned with more fundamental points. এটা ছাড়ুন.
আপনি এই অর্ডারটা
It is on record.
আরে এটা পুরো হাইকোর্টই অন রেকর্ড, কোর্ট অফ রেকর্ড, তোমার সাবমিশনের রেকর্ডে চলে যাবে।
Give me the advantage. You will get the advantage.
No, of course he should. Why not? All lawyers we are meant for that.
এইটার পেপার বুক কার্তিকে শোনা
You get
493 ডিএটা কোথায়? ওইখানে আছে, তারা দেখি দাও। আর ক্যান অ্যাপ্লিকেশন 6 and 7 ওয়েট করো দেখি। দুটো ফাইলের থেকে ক্যান অ্যাপ্লিকেশন দুটো except can 6 and 7, is there any other application?
From my end, there is.
No, from no, all others have been disposed of accordingly.
All were allowed to forward.
Excepting mine,
Yes,
not all are
because
allowed.
his point was different.
So Mr. Banerjee stands on a unique position.
As usual. The worst sufferers are with me.
Was sufferer is a state who is not able to fill up the posts. পিছনে টাকা দিয়ে টাকার পেছনে
কোথায় অর্ডারটা দিয়েছে? Yes, to the learned advocates appearing for the respective parties have concluded their arguments. That's what it said. এটাকে তোমার এটাকে এটা কি না না এফিডেভিট দুটো বের করো। State has filed 2 affidavits.
But
That affidavit,
the additional affidavit only in one matter. And that matter affidavit. But if he can.
no, you the report which was that has been annexed to the
Paper book, that additional report is not there.
Achha.
That as directed by the coordinate bench, that has been filed separately.
when did you file it?
সবই আমরা ফাইল করে দিয়েছি। হ্যাঁ আচ্ছা আচ্ছা।
পেয়েছেন এফিডেভিটটা? না this is the one you filed. আচ্ছা
Only in one matter.
হ্যাঁ
Only in one matter.
এইটার আরেকটা কপি তো থাকবে।
Exception also.
আমার ওটাই।
আর মেইন ফাইলটা ওখানে আছে তো? Yes, thank you.
Deeply obliged.
হ্যাঁ বলে দিচ্ছি।
Please, any one of you take the responsibility of putting your appearances with all the applicants, etc., because we face this difficulty. Please, any one of you take the responsibility to give a list of the advocates applicant.
এই আগের দিনে যে অ্যাপিয়ারেন্স ছিল ঠিকই তো আছে, তাহলে ঠিক আছে।
একসাথে বসে প্যারাটা এগ্রি করতে হবে ওটা।